Met this Lordship. I beg to mention hearing item.
Yes, Mr. MT, any mention?
My lord,
Any mention?
my lord.
Yes, what is it?
Item 12 is, I'm the petitioner, but I am bringing on behalf of In Mosui, respondent that.
Item 12.
Yes, my lord.
So this is admission.
My lord.
We will see when it comes up. Let's see the last order. At
Yes,
this-
there is
okay.
an order of this
Yes,
court.
so let me see the last order.
My lord.
Okay. Yes, Mr. Senti.
May it please, my lord. My lord, the anticipatory bail, which was withdrawn yesterday, my lord, we have bifurcated it, and then we have filed. We are in the process of filing it, my lord.
Okay.
My lord, I may be allowed to move those anticipatory bail applications unlisted, my
Okay.
lord.
Okay.
Deeply obliged, my lord.
Yes.
Lordship, I'm appearing on behalf of my senior Moa Jamir. I would like to mention hearing item number 59. Lordship, my senior has some personal difficulties to take up the matter today, so kindly miss it after 1 week for hearing.
Mr. So-and-so
59.
makes a mention on behalf of Mr. Moa Jamir, the learned counsel for the petitioner, and seeks adjournment of the case for a week. Prayer is allowed, listed after a week.
Lordship, a similar prayer for item number 4, which is listed for admission.
Item?
Item number 4,
4, let it come up as per the list.
my lord. Please, sir.
For motion, item number 1.
Yes, Lima.
Yes, Worship, this contempt petition has been filed for non-compliance with direction passed by this noble court
Okay.
and WPC number 229 of 2021.
Okay.
The order is at page number 12. And the Worship, the relevant portion is at page 18, para 6. Page 18. Para 6.
Yes.
Yeah, right, Worship. In view of what has been said above, this court is of the view that of the considered view that the petitioner service the petitioner deserves regularization of her service so that she would be entitled to enjoy pension and pensionary benefits. Therefore, the immune note given under UN number so and so by the additional secretary to the Government of Nagaland, PNR Department, so and so on 18/7/2022, reproduced here and above is quashed and set aside, and the respondents are directed to regularize the service of the petitioner within a period of 3 months from the date of physical copy of this. So far, the state respondent gave not come back to this.
Mr. Lima Wabang, the learned counsel for the petitioner. Stop. This contempt petition has been filed for deliberate violation of the judgment and order dated 26/4/2022, passed by this court in WPC number 229/2021. Issue notice to the respondents, returnable within 4 weeks. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the respondents by registered post with AD within a period of
2 days. 2 days.
2 days from today, listed after 4 weeks.
Obliged.
For motion, item number 2 and 3.
Yes,
Please, Lordship.
yes.
Lordship, this present is filed for impleadment of respondent number 1 in contempt petition 23 of
Respondent
2022.
number 1.
Lordship. In contempt petition 23 of 2022, Lordship. Who is the additional deputy commissioner? Lordship, during the pendency of the contempt petition, the respondent number 1, Shri Pakon Pom has been transferred to some other places. So, upon which Shri K. Rangping Higwe has taken charge of the office of the additional deputy commissioner. Is it Mon on 06/01/2023. So Lordship, my humble prayer is to kindly implement the new ADC, that is Sri Keirang Deng Hukui, as respondent number 1 in the contempt petition, Lordship.
As respondent number 3.
1, Lordship, 1.
How 1?
Respondent number 1, Lordship.
How 1? It should be 3.
No, Lordship, the ADC has been transferred to some other place, Lordship.
This is contempt.
Lordship, yes.
This is contempt.
Lordship.
So unless the matter is disposed, the contempt remains against petitioner respondent number 1. We do not know who will be answerable. So you cannot just omit respondent number 1 because he has transferred. As respondent number 3.
Lordship, okay, Lordship.
Can I make your correction?
Lordship.
Yes. You give him. Make correction. Mr. So-and-so. Learned counsel for the applicant. Stop. This application has been filed. For impleading Pakon Pom NCS, the Additional Deputy Commissioner Tizit Nagaland as the respondent number 3 in the contempt petition. in view of the transfer of the incumbent, who is the respondent number 1? Prayer is allowed? Stop. The applicant is allowed to implead Sri Pakon Pom, NCS, the Additional Deputy Commissioner, TZ. The present Additional Deputy Commissioner, TZ Nagaland, as the respondent number 3. Stop. The application stands disposed. In the main contain. In the main contain. In view of the order passed in IA Civil number 60/2023, Sri Pakon Pom NCS, the Additional Deputy Commissioner Tizit Nagaland, is impleaded as the respondent number 3. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the newly impleaded respondent number 3 within a period of
Lordship, it's K. Rangding is the new additional deputy commissioner, Lordship.
okay, within a period of
3 days, Lordship.
yes. So in that petition, in place of Pakon Pom, oh, you write this name, Kia Randing. You just see here NCS, Additional Deputy Commissioner and Administrator TZ Town Council, Mount Nagaland. So wherever the name Pakon Pom NCS arises, okay, is inserted, you replace it by this name. Stop. The registry. Within a period of how many
3 days, Lordship.
have we noted? The registry shall make the necessary correction in the post title.
Obliged, Lordship.
For admission, item number 4.
May I please, Lordship?
Yes.
Lordship, if Lordship may kindly allow the matter to come up for hearing after 2 weeks.
What is the matter about?
It is regarding posthumous regularization, my lord.
On the prayer of the learned counsel for the petitioner listed after 2 weeks.
Obliged, my lord.
For admission, item number 5.
Yes, Mr. B.N. Sharma, what is this?
Chief, I am respondent in this case.
Yes. Who is for the appellant?
Appellant is advocate coming from Gauhati. Lordship, as per record, it is appeared that from 14/11/22 even till day, appellant is not appearing. before this
14,
court.
11,
22 till day.
14, 11, 22. Let us.
Altogether 6 occasions, including today. They might have abandoned this appeal, Lordship.
The last order was 9/5/23.
Lordship,
9/5/23.
apparent from the record, it is appeared that every day appellant is absent.
Weather limitation, section 5 has been condoned.
Yes, Lordship. There has been a total delay of 102 days.
By which order?
Lordship?
By which order it was condoned?
No, delay is not condoned, Lordship.
Delay is not
Not
condoned.
condoned, Lordship, till date. No delay condoned. till date. This appeal is filed, Lordship, in the year
Mr.
2020.
B.N. Sharma,
Lordship,
what was the order dated 9/4/2021? Let's see.
Lordship, there is an order of this Lordship. Your Lordship, yes, Lordship.
9/4/2021.
As per direction of this court, the appellant ought to have published substitute notice in 2 newspapers consecutively. That has not been done. Because of that, your Lordship was pleased to pass an order on 9/4/22. Later on in the month of May, last order in the month of May, that order issued for publication of substitute notice, this court held that it is now infructuous since the respondents are appeared before this honorable court.
So this 9/4/2021 has not been complied.
Not been complied. But the respondent appeared, later on respondent appeared before your Lordship. How it is, we do not know. Without publication of the substitute notice, Lordship.
Respondent means
Respondent 2, Lordship.
you are the,
Respondent 2.
who is respondent to?
I'm representing Respondent 2. Yes.
Who is respondent to? The
The
driver,
accused, the
owner?
driver. The driver. The vehicle owner come the driver.
Okay, vehicle owner come the driver. Respondent to. So the order 9/4/2021 has more or less become infructuous.
Yes, Lordship.
Okay.
Our only problem is, Lordship, since filing of the appeal till date, the appellant is not diligently pursuing the matter at all. And rather, it is appeared that they have abandoned this appeal, Lordship. So it is a fit case for dismiss.
No, we have not still come to the appeal stage. We are still in that condonation,
Lordship,
in that condonation.
Lordship.
Let's see properly. Yes, wait. Mr. B.N. Sharma, the learned counsel for the respondent number,
One.
claimant respondent number one.
Yes, Lord.
And MS so the learned counsel for the respondent number two. Stop. This application has been filed. Under Section 5 of the Limitation Act, for condoning the delay in filing the connected MSC appeal. Stop. After the application was filed, it appears that the petitioner, the applicant is not at all interested to prosecute the application. Stop. The order shows that, the order passed by this court shows that after the filing of the application, the petitioner has remained absent on several occasions when the matter was listed. Stop. On 10/2/2023, 24/4/2023, and 5/5/2023, when the case was listed, there was no representation on behalf of the applicant. Stop. It appears that the applicant is not interested to prosecute the application. Stop. This code. The application filed by the applicant for condoning the delay is accordingly dismissed. Stop. That is okay. In the main MSC. No order need to be passed, na? MSC too? Because actually we have not started with the main case. Okay. Yes.
Item number 6 and 7.
May it please, my lord.
Yes.
Lordship, we are ready for admission hearing, both the parties. We have fixed it for admission hearing. However, here it has not come out as fixed.
Who is for the government? This is contempt.
Yes, I'm
No.
appearing for the response.
Lordship, the contempt will be, the outcome of the writ petition will cover the contempt.
What is the outcome of the writ petition? What should be the outcome of the writ petition?
Because they are saying that I'll be appointed as.
You have, you are the respondent number,
1 and 2 in the contempt petition, my lord.
no, and for the writ petition?
In the writ petition also, I am for the respondent number 2, 3, and 4.
And who is for the government? Well, the government is a party.
Lordship,
Yes.
Who is for the government? 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 government advocates and not even one standing for the case on behalf of the government. What is this? Something is very wrong with you all. Who is handling the case on behalf of the government? Oh my God.
Lordship, I'm representing the government.
At last. Have you filed your affidavit?
No.
At least be smart. You're a government advocate. Always very casual, leisurely, appearing on behalf of the government. How will we correct you all? And you are not even aware about the case, whether this is fixed.
Lordship, contempt is in regard to
The learned counsel for the petitioner is saying that the petition, writ petition first has to be disposed.
Yes, Lordship.
But in the writ petition, we are challenging the addendum. And in view of the addendum, we cannot consider the case of the petitioner for appointment on compassionate ground. Because as per the addendum, it says that appointment on compassionate ground has to be on the basis of the date of date, not from the date of the
Expiry.
application.
From the date of expiry. So what has happened is the respondent have included the names of those who have died 30 years back, those who have not applied, and all those who have died since 1991, those who have died without even application, they have shown in the seniority list, Lordship. I'm also, Lordship, will kindly see that
Ms. Sokre, I think something has to be done with your government advocates. This cannot go on. And if this gone, this court will come down heavily, very heavily
Lordship.
on the individual lawyers. Not gone leisurely, always leisurely for the government.
Lordship.
You are representing the government at least. Be responsible. The government has appointed you to be responsible, not casual. I have made up my mind to come down very heavily on government advocates, individually. I'm not going to spare. If you are taking up the government the case of the government so leisurely and so casually, this court will not spare you. You file your affidavit in the writ petition.
Yes, Lord.
Are you aware about the case?
I'm aware of the case. The petitioner is challenging the addendum in the commissioned appointment.
Who has issued the addendum? Who has issued?
State has issued.
State has issued. Are you not? Do you have no objection to the writ petition filed by the state,
Lordship,
by the petitioner?
Lordship, allow me 3 weeks to file my counter.
You have wasting the time of the court. See, it is the action of the state. You are supposed to defend. At least defend the state responsibly. Not in this manner. This is something which should be avoided.
Lordship, the petitioner's father died in 2016. He ought to be at serial number 1 if to go by the application, because
Sri Mr. Moemchan, the learned senior government advocate, is allowed 3 weeks' time to file affidavit in opposition in WPC 115/2022. Stop. It is made clear that if no affidavit is filed on the next date fix, the officer or the government counsel responsible shall be penalized with fine.
obliged, Lordship.
Item number 8.
Yes, Mr. CT.
Last occasion on 22nd May, Lordship has allowed the learned Crown Advocate to file the detailed report of the inquiry, Lordship.
Have you filed, Mr. Moore?
No, Your Lordship. The department is communicating with the Nagaland Lokayukta police. So allow me, Lordship.
Nagaland Lok Ayukta Police.
Now vigilance has been changed to Lokayukta. Before it was vigilance, now it has been changed to Lokayukta. So I have a police establishment led by Inspector General of Police. So if my learned senior friend is no objection, Lordship, allow me 3 weeks time.
Direction was issued as far back as on 27th March, Lordship, this year. That was the first order by which my learned friend has been directed to file the affidavit. And thereafter again, the last order was on 22nd May.
You are only supposed to enclose the report dated 7/7/2011 concerning the petitioner. What is taking you so long? The order was passed as far way back as 27/3/2023. Mr. Moore,
Lordship,
you will
allow me
never
to,
learn.
Your Lordship, Your Lordship, allow me to comply with the last order. I filed the counter, but Your Lordship has made certain observation and again asked me to file again. That is why, Your Lordship.
You have not complied. You have not complied. You have only stated that the report is very bulky and you will be producing the same only during hearing. This court wanted that relevant portion of the file which concerns the petitioner, correct?
Lordship,
And you were directed to file affidavit on that.
Your Lordship, I understand that. That is why department is communicating with trying to trace out that very file so that I would be.
You have brought that file. You had brought that file before this court. And you had made a mention that the file is very bulky. You have produced that file before this court. And this court wanted only that relevant portion of the file which concerns the petitioner. Many a times there is delay on the part of the government, but many a times it is the government advocate who is responsible for the delay. That should be avoided.
Yes, Your Lordship.
This is too much. This is too much. Mr. Moa Jamir, the learned senior government advocate, is allowed 2 weeks' time to comply with the order dated 27/3/2023. Failing which, necessary orders shall be passed against the government advocate. Listed after 2 weeks.
Item number 9.
May I please, Your Lordship?
Yes.
Lordship, I'm mentioning on behalf of Tiba. Lordship, may kindly grant 2 weeks' time to file counter reply to affidavit reply by the petitioner.
What is the case? Who is for the petitioner? Who is for the petitioner?
Lima Doshi.
You have filed your affidavit?
Lordship. Lordship, may kindly grant to file counter reply to affidavit reply filed by the petitioner.
Counter reply?
To affidavit reply by the petitioner.
Counter reply. Rejoinder to the affidavit in reply or okay. By the order dated 22/5/2023, this court had observed that if no rejoinder affidavit is filed by the next date, the case will be taken up on the basis of pleadings available on record. Stop. None appears for the petitioner. Listed for admission hearing after 2 weeks. The prayer on behalf of the government for filing rejoinder affidavit to the reply filed by the petitioner is rejected.
Item number 10.
May I please, Your Lordship?
Yes.
Your Lordship, I'm appearing on behalf of my senior, Tompo Pangyanar, counsel for the petitioners.
Okay.
Your Lordship, may kindly grant us 2 weeks' time to file our reply to the affidavit filed by respondent number 4.
Respondent number
4.
4.
Yes, Your Lordship.
MS Renzo, the learned counsel for the petitioner, 6 for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 4. Prayer is allowed.
Your
Listed after,
Lordship, there is an interim.
listed
So,
after 2 weeks. The interim order passed earlier shall continue till the next returnable date. Okay.
much pleasure.
Item number 11.
May I please the Lordship?
Yes.
Lordship, I'm mentioning on behalf of my colleague, MS Lucy, Lordship.
Yes.
Lordship, I've been instructed that she is on bereavement, Lordship. So, Lordship, may I please to grant 3 weeks time, Lordship. For
Yes, Mr. Yangawati,
I,
you were supposed to file reply. Have you filed?
I have not filed, I will not fly.
You will not file.
Yes, but my interim be continued. Lordship.
Okay. Mr. Yangawati, the learned counsel for the petitioner submits that they will not be filing the affidavit in reply on behalf of the petitioner. Stop. Mr. Bij Momi submits that MS Lucy, the government advocate,
Is on bereavement. Lordship.
handling the case on behalf of the state respondent is in bereavement, and therefore six for
3 weeks time.
3 weeks time. Prayer is allowed, listed after 3 weeks. Stop. The interim passed earlier shall continue till the next returnable date.
Lordship. Lordship.
Item number 12.
May I please the Lordship?
Yes.
Lordship, by order dated 29/5/2023, Lordship, the Honorable Court has directed the state respondent as to why, as submitted by the petitioner, with regard to non-issuance of the release order, Lordship.
Yes.
Lordship, I have intimated the department on 30 May of 2023, Lordship, but so far I have not received any instruction, Lordship. I want to the state respondent to come up with a proper instruction, Lordship, by way of placing the documents, Lordship. But so far, Lordship, I'm yet to receive instruction, Lordship. So, Lordship, may please to grant another 2 weeks time, Lordship, to get a proper instruction, Lordship.
Okay.
My lord.
As ordered on 29/5/2023, Mr. Bij Momi, the learned government advocate, shall come with necessary instructions on the next day,
Lordship.
listed after 2 weeks.
Hello.
Item number 13 and 14.
Yes, Mr.
Lordship, I am for
Yes,
the
Sharma.
respondent claimant.
Yes, why you have not
Uh,
deposited
Lordship,
50%? We'll dismiss your appeal.
My apology, Your Lordship. There's a technical problem in the computer system of the insurance company, Your Lordship. So my humble prayer is that yesterday only, Your Honor, we have received the intimation letter from the insurance company.
What was the awarded amount, Mr. Bin Sharma?
Seventeen lakh 62,000, Lordship.
It is the claiming composition. So
What is the award?
14 lakhs. 14 lakhs.
When can you deposit?
2 weeks time may be granted, Your Lordship.
Why Why 2 weeks?
Lordship, there's a technical problem, so
That technical problem will continue for 2 weeks.
I'm not sure, Your Lordship.
You're not sure.
Yes, Lordship.
Okay, we'll vacate the order. You make the deposit.
Yes, Lordship, we'll do that. 2 weeks time may be granted, Lordship.
The insurance is the applicant.
Yes, Lord.
Stop. Heard Mr. So-and-so? Learned counsel for the appellant insurance company. And Mr. B.N. Sharma, the learned counsel for the
Respondent claimant.
respondent claimant number 1. And MS so-and-so for the respondent number 4. Mr. So-and-so, the learned counsel for the appellant insurer submits that the order dated 21/3/2023 passed by this court could not be complied with due to some technical problems in the computer system of the appellant. Stop. The learned counsel for the appellant therefore seeks for 2 weeks' time to comply with the order dated 21/3/2023. 2 weeks' time is accordingly granted to comply with the order dated 21/3/2023. It is made clear that if the 50% of the awarded amount is not deposited as per the order dated 21/3/2023, the said order shall stand automatically vacated, listed after 3 weeks.
Item number 15.
Lordship, same order may be passed for item number 14 also.
There also you were directed to deposit 50%,
Yes, Lordship.
same order.
Much obliged, Your Lordship.
Have you called?
Item number 15.
Yes,
Yes,
Mr.
Your
Inform.
Lordship. My lord, in this matter, pleadings has been completed.
You have filed reply affidavit
Yes,
also?
my lord. I have served a copy also. So may I plead that this matter may come up on 26th for admission hearing.
That is submitted by the learned counsel for the parties, that pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
My lord, interim order may be extended.
The interim order passed earlier shall continue till the next returnable date.
And my lord, in the meantime, the lower court record may be called for.
Lower court record has not been called.
It has been called on the last occasions.
Whether it is there, lower court? Not received. Stop. The lower court record has not been received. Registry to send reminder.
Much obliged.
Item number 16.
May I please, Your Lordship?
Yes.
Lordship, I'm appearing on behalf of my senior advocate Nancy Lota. I have instructions from my senior that will be appearing for respondent number 2. Kindly grant us 4 weeks' time to file both our vakalatnama and affidavit in opposition at the same time.
At the same time.
Yes, Lordship.
Why not Vakalat Nama first? You are MSK Chakra.
Lordship, I'm just appearing on behalf of Advocate Nancy Lota.
Your Nancy Lotha has sought for several adjournments. It is. Yes. On 14/3/2023, Ms. Nancy Lotha appears. On 10/4/2023, Ms. K. Chakra mentions on behalf of Ms. Nancy Lotha. On 8/5/2023, you had served for 2 weeks' time. Who is respondent number 2? Who is respondent number 2? The victim?
Yes, I complain in Lord.
So it's high time for Nancy Lotha to file affidavit and Vakalat Nama. Okay. Next time, don't come with this submission. Okay.
All right, Lordship.
MS so. Makes a mention on behalf of MS Nancy Lotha, the learned counsel for the respondent number 2, and seeks adjournment of the case to file Vakalat Nama as well as the affidavit in opposition. Prayer is allowed. Listed after 3 weeks.
Blessed Lordship.
Item number 17 to 26.
No, please, Your Lordship.
Yes.
Lordship, here the pleadings are complete, so this may be listed for admission hearing after 2 weeks, Your Lordship.
Okay.
And Your Lordship, item number 18, Your Lordship, this may be segregated from the
Item number
18, Your Lordship. This may be segregated from the text list of cases, Your Lordship.
is item number 18.
1 WPC 14,
Okay,
2022, Your Lordship.
Why, Ms. Inaoli? Why?
Your Lordship, the facts are different, Your Lordship.
Facts are different.
Yes, Your Lordship.
And the others, the facts are same?
Yes, Your Lordship.
Segregate WPC 14/2022 from the bunch of writ petitions. The rest of the writ petitions shall be listed for hearing in the usual course. Listed accordingly.
Much obliged, Your Lordship.
Item number 27.
Yes, Lordship.
Lordship, I'm appearing for the petitioner.
Item?
Item 27.
Okay.
Pleadings are completed, Lordship. However, Lordship, may I point out that this matter may be listed after a week. I have some personal difficulties studying.
Pleadings are completed?
Yes, Lordship.
Yes, Lordship. Yes. It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
Lordship, after 1 week,
Usual course.
it's a pension matter. Lordship.
It's all right. I think we should give first preference to the hearing matters. Because this admission and order matters are overtaking hearing matters.
Item number 28.
Please, Your Lordship.
Yes.
Lordship, I will be granted another 3 weeks' time to file my reply, Lordship.
Reply to the
The counter filed by respondent number 1 and 2, Lordship.
respondent number 1 and 2.
Yes, Your
Government.
Not government, Your Lordship. It's a Northeast Zone Cultural Center, Lordship.
Okay.
Treat director.
Okay. Okay. Your reply is to which respondent?
1 and 2, Lordship.
1 and 2. MS. Esther. The learned counsel for the petitioner. 6 for 2 weeks' time. To file affidavit in reply to the affidavit in
Lordship, 3 weeks'
opposition
time, Your Lordship.
filed by the respondent number 2 and 3. Prayer is allowed, listed after 3 weeks.
Interim may be continued, Lordship.
The interim order passed earlier shall continue till the next returnable date.
Item number 29.
May I please, Your Lordship.
Yes, Ms. Liwe.
Your Lordship, my sincere apology, Your Lordship. On the last occasion, this Honorable Court has granted me 3 weeks, keeping in view that the appropriate orders will be passed. However, Your Lordship, while drafting the affidavit, Your Lordship, affidavit is ready. However, on 2, I have to make 2 clarification, and therefore I have sought that clarification, and within 1 week they will produce, and within 1 week I'll file, Your Lordship. So this court may be gracious to grant 1 more week, Your Lordship. My affidavit is ready, Your Lordship, otherwise, just to incorporate the 2 orders or 2 clarifications.
MS Livika, the learned government advocate, submits that the affidavit is ready. However, a little clarification is required from the department, and therefore a week's time is sought. Prayer is allowed, listed after a week.
Much obliged, Your Lordship.
Item number 30.
Yes.
May I please, Lordship. Lordship, the counsel for the respondent is seems like it disposed.
Who is the counsel?
I'm mentioned on behalf of Tiba. Lordship, may kindly grant 2 weeks' time.
No private respondents,
No,
only government.
Only government. Lordship, in that case, 3 weeks' time may be given, Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course. Okay.
Item number 31 and 32.
Yeah, please, Your Lordship.
Yes.
Your Lordship, affidavit is ready for vetting, Your Lordship. So 2 weeks may be granted.
Okay. MS Livika, the learned government advocate, submits that the affidavit on behalf of the state respondents has been sent for waiting, and therefore 2 weeks' time may be granted to file the affidavit. Prayer is allowed, 2 weeks' time, listed after 2 weeks.
Much obliged.
Item number 33.
Yes.
May I please, Your Lordship? Your Lordship, I'm appearing on behalf of my senior Tompo Pongyener,
Okay.
counsel for respondent number 6. Your Lordship, there is matter related to this present case still pending in division bench, numbered as WBC 261 of 2021.
What is Miss Ayami, what is the case about?
Your Lordship, here the petitioner is challenging the appointment of the private respondent, Your Lordship. And the
Why
servi-
similar matter?
The service rule is under challenge, Your Lordship, in WPC 261/21, which is
Oh.
pending before the division bench.
Okay.
So let Your Lordship, let the matter come up after disposal of WPC 261.
Service rule is challenged in WPC 261.
261, Yes, Lordship. Engineer Watt versus State.
Okay, Engineer Gauhati, yes. That is regarding that two streams,
Yes, Your Lordship.
employment stream and.
Yes, Your Lordship.
Okay. The learned counsel for the parties seeks adjournment for 3 weeks. Prayer is allowed, listed up to 3 weeks.
Lordship, Lordship.
Item number 34.
May I please, Your Lordship?
Yes.
Lordship, I'm appearing on behalf of Mr. Gauhati, CJC, for respondent 4. Lordship, we are yet to receive instructions, so I pray that 3 weeks time may be granted to us.
Ms. Okay, your file. What is the matter?
My Lord, this matter is a dispute between PWD and the Border Road Organization for road construction in New National Highway 720B from Tungsang to Longqing.
A dispute between Border Road Organization and PWD.
Yes, Lord Chief. And here the petitioner.
And how you are in the picture?
Here the petitioner is the contractor.
Okay. You file your affidavit first. Tell Mr. Gauhati. So it is a dispute between you and the central government, between PWD, BRO.
Yes. They are not able to over the national highway to the state, whereas the ministry has already directed the.
Yes, Mr. Gauhati. Why is it difficult for you to hand over this road to the state?
Lordship, unless I get an instruction, I cannot be able to.
The government and the petitioner is caught between. Because I think you are for your bills.
Yes, Lord Chief.
Yes.
Lordship, I pray that I may be given 4 weeks
I
time,
will
so
give
that
you.
otherwise, without the
And the
instruction,
government
I
is saying
cannot.
that they cannot take over the road unless you allow them.
Yes, Lordship.
And
So
unless,
I may be given 4 weeks time, Lordship, so that I will get the proper
Okay.
instruction from the government,
Yes, Lordship.
the central government.
okay. Mr. Gauhati, the Leonard CGC submits that he may be allowed 4 weeks to obtain necessary instruction from the respondent number.
4.
Respondent number 4.
Yes, Lord
Your
Chief.
respondent number from the
Yes,
respondent number 4.
Lord Chief, till now none appear for respondent number 3. It's more.
He is appearing. You are appearing for 3 and 4. More.
Lordship, more they have their full standing counsel. I think Mr. Mojame is appearing for more in all the
And
cases.
where is Mr. Muaz Amir? No, Muad Jamir is for NIDC.
He's appearing for more also.
You are for Muad Jamir. Muad Jamir is the standing counsel for MOT.
Or NSIDC.
Because, Lordship, more they are engaging, one
More.
Mr. Miti also, one more also. That is where there is some conflict. So for the central, I agree, but for more and I am not appearing unless they give me instruction to appear. So notice may be sent, Bishop.
You are for respondent number 4.
Yes, Lordship.
Let me just fit a bit. Four.
You are for true.
Mr. Yangawati, you are for BRTF.
Yes, for the BRDF, yes. 4.
So 3. What about 3? Any order passed?
So this is for more. So let the notice go, Lordship.
Lordship, we has served the notice through registered AD on 29/22.
By which order?
By order dated 9/5/22
Is 15 and the state
and on 29/22 we have
petitioner shall
served the
hand over
notice.
adequate number of copies. Written service in respect of respondent number 3.
Camera to the
Service of the government is still yet to receive instructions. Yes, notice is still awaited for respondent number 3. Why don't you take fresh steps
Yes, Lordship.
by registered post again? Because notice awaited. You take fresh steps.
Yes,
Okay.
Lordship.
What was the last order, ma'am? The last line? Four. The learned counsel for the petitioner shall also take steps for service of notice upon the respondent number 3 by registered post with AD within a period of
1 week.
7 days from today. Stop. Listed after 4 weeks for enabling the respondent number 4 to file the affidavit.
Most glad.
Much obliged.
Yes.
Item number 35.
My pleasure,
Yes,
Lordship.
yes.
Lordship, I'm mentioning on behalf of TIPA.
How much time?
3 weeks time may be granted.
Okay. For what?
To file
Affidavit.
counter affidavit.
The learned government advocate seeks for 3 weeks' time to file affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Much
Thank you, please.
Item number 36.
Lordship, we have received affidavit from both the parties and it's ready for hearing, Lordship, admission hearing. If
No
my
more,
Lord,
no more admission hearings. Only for usual hearing. Pleadings are completed. The matter may be listed for hearing in the usual course.
in the meantime, Lordship, then if there be any affidavit in reply to be filed, if any, I may be given.
In the intervening period, the parties may be allowed to exchange affidavits, if so advised.
Obliged, Lordship.
Item number 37.
My pleasure, Lordship.
Yes.
Lordship, the affidavit is ready. I'm waiting for the signature.
Okay.
From
You-
the
you
central
are for-
government. I'm for the central government.
Central government.
Yes.
Lordship, I'm for 3, 4, and 5.
3, 4, and 5.
Lordship, the state until unless there is a statement against the state filed by the Union of India, Lordship, the state has got nothing much to say because we are just a dispersing agency, Your Lordship, nodal agency.
Okay. Mr. Yangarwati, the learned CGC. Yangar, you're for 1.
1 and 2, 1 and 2, 1 and 2, 1 and 2.
One and two.
For the respondent number 1 and 2, submits that the affidavit has been sent for waiting, and therefore he may be allowed 2 weeks' time to file.
Lordship, at least 3 weeks time because it has to come back from.
Slowly you are stretching. 3 weeks' time. Okay. Mr. N. Angami, the learned senior government advocate, submits that the affidavit on behalf of the state respondents will depend on the affidavit filed by the Union of India, listed after 3 weeks. Okay.
Much obliged.
Much obliged.
Item number 38.
Lordship, in this matter also the pleadings are completed, Your Lordship.
Okay. Okay. Pleadings complete. Ma'am?
Yes, Lordship. Lordship, I pray that this matter may be listed after 1 week for hearing, Lordship.
It is submitted by the learned counsel for the parties that pleadings are completed, and therefore the matter can be listed for hearing. Listed for hearing in the usual course.
Much obliged.
Obliged, my Lord.
Item number 39.
Lordship, I pray for 2 weeks' time to file affidavit in reply to the affidavit in opposition. We have already filed the documents that.
Affidavit in opposition filed by the state.
Yes,
Filed by the
Lordship.
state.
Lordship.
MS Jakhali. That Jimomi, sorry. The learned counsel for the petitioner, 6 for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed after 3 weeks.
2 weeks, Lordship.
Okay, 2 weeks, listed after 2 weeks.
Obliged, Lordship.
Item number 40.
Yes.
May I please, Your Lordship? Your Lordship, I'm appearing on behalf of my senior Tompo Ponginer,
Yes.
counsel for Respondent 7. Your Lordship, we are yet to file our affidavit in opposition, so kindly grant us 2 weeks' time.
Yes, Mr. Wati.
Yes, Lordship, I've received the affidavit of association filed by the state this morning.
Okay. You want to file reply also?
Lordship.
Mr.
2 weeks, Lord.
Wati Jamia? 6 for 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Stop. MS so-and-so, also 6 for
2 weeks' time.
2 weeks' time to file affidavit in opposition on behalf of the respondent number
7.
7. Listed after 2 weeks.
Much obliged, Your Lordship.
Item number 41.
Yes, Ms. Esther.
Lordship, here the state is set to file the counter, Lordship. Matter
Yes, how much time?
Lordship, 3 weeks' time.
Matter relates to regularization of work charge employee, Lordship. He has been serving for more than 33 years now, Your Lordship. So as per the scheme, he is eligible, Your Lordship.
Okay, let them just file a small reply. Mr. Majamir, the Learned Senior Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Item number 42.
May I please, Your Lordship?
Yes.
Your Lordship, may kindly grant me 3 weeks' time to file counter, Your Lordship.
Okay. Okay?
Yes, Lordship.
MS Inaoli, the Learned Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Prayer is allowed, listed after 3 weeks.
Much obliged, Your Lordship.
Item number 43 to 47.
May I please, my lord?
Yes, Mr. Nangam.
Lordship, the item number 43 to 47, I'm appearing for the state respondent 1, 2, and 3. Lordship, I'm here to receive instruction, Your Lordship.
1, 2, and 3.
Lordship, there's a private respondent also, Your Lordship, in this matter.
Mr. Fuseko.
Lordship, I'm here to.
Therefore, private respondent.
Yes, Lordship.
Private
Which
respondent.
one for? In 43, 45, and 47.
43,
45 and 47.
the rest you are not appearing.
No, Lordship.
43, 43,
45 and 47.
43, 45, and 47.
Your Lordship, I'm for
Yes.
respondent number 4 in item number 44 and 46.
44, 44,
And 46.
44, and
46.
46. Okay. And Mr. Nangami,
Lordship.
for all the respondent 1, 2, 3.
Yes, yes, Your Lordship. In all the cases.
Have you filed your affidavit?
No, Your Lordship.
And you?
No, Your Lordship.
We give them time to file their affidavit, okay?
My lord, there's an interim order.
Yes, 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 we'll extend it. Mr. Nangami, the Learned Senior Government Advocate, 6 for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. 1, 2, and 3. Stop. Mr. Fuseko, the Learned Counsel for the respondent number 4.
No, Lordship.
4 in WPC
19,
19, 20, 23,
19, 21, and 23.
WPC 21/2023, and WPC
23.
23/2023.
Lordship.
Also 6 for 3 weeks' time
3 weeks'
to
time.
file affidavit in opposition. So also, Mr. So-and-so, Learned Counsel for the respondent number 4 in WPC 20/2023 and WPC 22, correct? /2023 as makes a similar submission. The respondents are allowed 3 weeks' time to file their affidavit in opposition, listed after 2 weeks.
Obliged, my lord.
Yes.
Deeply obliged, my lord. Please.
Item number 48.
May I please the Lordship?
Yes, Mr.
Lordship, by order dated 22/5/2023, the Honorable Court is gracious enough to grant us 2 weeks' time to file counter affidavit, Lordship.
Correct.
However, Lordship, there is a certain observation which has been submitted by the learned counsel for the petitioner, Lordship saying that there is an urgency. And then this court has
What
passed
is the
a
matter
resolution.
about? Mr. City?
The state government has issued a notification dated 23/3/2022, by which the backward quota of the 6 backward tribes,
Correct.
after recognition of Tikir tribe, the quota has to be shared.
Has remained same
Yes,
for Tikir and Yimchongwar.
yes. They are to share. Lordship has issued notice on 4/4/2023.
Yes.
And then on that day, the observation was made to dispose of the matter expeditiously as possible in view of the urgency involved. Because after filing up this case, 2 advertisement has already been issued. We have missed those passes also. Therefore, in view of this, on the last occasion, that is 22nd May
So your
2023,
case basically is that the quota remains the same, whereas the number of tribe has increased
and then it is made to be shared
between
taken out
Yimchongwar and
from
Tikir.
Yimchongwar. The care they can get, but the
Yimchong.
loser is Yimkyong. It has to be shared
And
among the
you're
7.
for Yimkyong.
Yes.
You're for Yimkyong.
It has to be shared among the 7 backward tribes now.
Correct, correct.
Lordship,
So-
we have received the we have received the instruction yesterday, Lordship. Lordship, however, going through the instruction, Lordship, most of the documents is not at all legible, Lordship. So we have instructed the state respondent to bring the legible documents, Lordship.
Okay, it seems they are taking steps. At
Lordship.
least let us give them some time if they are taking steps.
Yesterday, they sought my consent. I have given my consent with
Okay,
one condition,
okay.
that, and those conditions are the order dated 4/4/2023 and 22/5/2023. These 2 orders may be taken note of by this honorable court, and they can take time, and on the next date, endeavor should be made to dispose of this case, Lord.
22
The issue involved is very simple.
22/5/2023.
Yes, Lordship.
Lordship.
That they also have not objected. Even duty also I am not objecting with that condition, Lord.
Your Yimkong. Your Yimkong quota has now been allowed to be shared by 2 tribes.
Yes. Instead of sharing
Instead
among
of
the 7
one.
tribes.
Ah.
Yes. That's the only, and government has already issued the order that it should be shared from among the 7 tribes. But in violation of that standing government order, it has been taken out from the Yimkyong quota only. So we are loser. And for not implementing the government order. That's why, Lordship, the issue is very simple.
That's why, can it be like this? They have increased the number of backward tribes, but actually the quota remains the same.
Yes. The cake remains the same.
Too many eaters.
Consumers have increased. And that piece of cake which is meant for me has been allowed to be shared by another tribe again.
I hope you very well understand.
Lordship.
Huh? He has actually cited his case by a very simple example. So we give them some time.
Lordship.
But expedite,
Lordship,
okay?
definitely,
Expedite,
Lordship.
because actually
Definitely.
unless these things are settled,
Yes, Lordship.
you are time and again coming up with advertisement
Lordship.
with the same quota. Advertisement on the basis of the quota for the Yimchongwar tribe being shared by both Yimchongwar and Tikir. So, when the government has actually included you as a backward tribe, then something has to be worked out for you also.
Definitely, Lord.
Not to nimble in some other quota. Mr. Bijmomi, the learned government advocate, submits that he has received the instructions from the department. However, most of the documents are not legible, and therefore necessary clarification has been sought from the government. Stop. Mr. Veto, therefore, 2 weeks' time.
Lordship.
2 weeks' time.
Let it be as a last chance, Lordship.
Stop.
In
For
that-
filing, for filing.
Lordship.
Yes?
Lordship, in that view of the matter, after 3 weeks, Lordship, if that is the last chance, Lordship, since we have to send it
Six
for
for 3 weeks' time.
Lordship, to be on the safer side.
For filing the affidavit in notice. Stop. It is made clear that there shall be no further adjournment, and the matter shall be taken up for disposal, either with or without the affidavit of the government,
Lordship.
listed after 3 weeks. Take note of that.
Lordship.
Okay.
Lordship. Much obliged.
Item 49.
Lordship,
Yes.
I have prepared state counter on behalf of the state respondents. Now I have to obtain the segregation. of
Yes,
name.
yes, we'll give you sufficient time. If you are at least showing the court that you are doing something for the government, this court will at least consider that, but just coming casually. How much time you require?
2 weeks time.
Okay?
Yes, Lordship.
Mr. Mohammed, the then senior government advocate, submits that the affidavit on behalf of the department is ready. The affidavit on behalf of the department, not is ready, okay? The affidavit on behalf of the department has been sent for waiting. And therefore, 3 weeks' time may be allowed to file the same. Prayer is allowed, listed after 3 weeks.
Obliged.
For admission, item number 60.
Yes,
Hearing virtually completed.
yes. What is your assistance to this court?
Just to produce.
Yes, let's.
Lordship, no, it's a regular case. Most of the judgment passed by the Supreme Court as well as by the Honorable Court with regard to payment of witches, those directions were issued when the trial court convicted the accused and subsequently acquitted an appeal. And certain direction has been issued for payment of 50%, 75%. However, in this case, Lordship knows, trial court itself acquitted the petition. So it's very difficult to find out the theoretic judgment covering the subject matter. However, Lordship, on the issue and the interpretation of reinstatement, the dismissal after acquittal, whether this person is entitled for the packages. So, Lordship, first, I'd like to place one judgment that is 2013. Done ECC.
Just wait.
I've given the list of books this morning. Lordship.
Yes, what is 2000?
2013 10 SCC.
2013 10
SCC.
SCC
324.
324.
Yes.
Para?
Lordship is a short judgment, 2-page judgment only. Subject matter is slight difference, however, Lordship, with regard to payment of languages, the principle has been laid down here. Married Lordship. The appellant was appointed as a teacher in the primary school run by a trust established.
Yes,
and
yes.
control. Is 324.
324.
Yes. 2013.
1310.
1310.
324.
Yes, Lordship.
Which para?
Judgment start from 325, Lordship. Two-page judgment only.
325.
Lordship, I'm sorry. Lordship.
No, no, no.
Yes, yes. Page 32, 332.
332.
Yes, Lordship.
332. 332. No, 332.
332, Lordship.
You are referring to 2013-10.
Yes, Lordship.
2013-10. And
starts from 325.
332. You are saying it's a short judgment, but actually the judgment
Yes,
runs in
I'm sorry,
many
Lordship.
pages.
I'm sorry, Lord. Lordship, okay. Lordship, paragraph 21, page 344.
344. Paragraph 21.
Yes.
This word reinstatement?
Yes, Lordship. Married Lordship.
Yes.
The word reinstatement has not been defined in the Act and the rules. As per the Shorter Oxford English Dictionary, Volume 2, third edition, the word reinstate means to reinstall or establish a person or thing in the place, station, condition, etc. To restore to its proper or original state. To reinstate afresh, and the word reinstatement means the action of reinstating, reestablishment. As per law, lexicon, second edition, the word reinstate means do reinstall, do re-establish, do place again in former state, condition, or office to restore to a state, position from which the object or person had been removed, and the word reinstatement means establishing in a former condition, position, or authority. As reinstatement of the deposed prince. As per so dictionary, the word reinstate means to place again as in position or in former position, to restore to a previous effective date. As per Black Law Dictionary 6th edition, restatement means to reinstall, to reestablish, to place again a former state, condition, or office, to restore to a state or position from which the object or person has been removed.
Okay.
That is the meaning of.
That is okay. That is a reinstate. That actually defines the meaning of reinstatement.
Yes, Lordship.
But reinstatement, after reinstatement,
yes.
In your case, what consequence should follow?
Lordship, I'll take your lordship directly to the finding in this judgment, lordship.
Same judgment?
Yes, same judgment.
Yes, which para?
Bara 40, lordship.
Para?
Bara 40.
40.
Yes, lordship. Page 358.
359.
358.
Para 40.
Yes.
Okay.
I'm not referring to the facts, lordship. The learned single judge agreed with the tribunal that the action taken by the management to terminate the appellant service was per se illegal, but set aside the award of privileges by making a cryptic observation that she had not proved the factum of non-employment during the intervening period. While doing so, the learned single judge not only overlooked the order passed by the tourism page and so case, but also wrote the decree which prohibits an employee from taking employment elsewhere, and that it was not even the blatant case of the management that during the period of suspension, the appellant had left the headquarters without prior approval of the chief executive officer, and thereby is entitling her from getting subsistence allowance, or that during the intervening period she has gainful employed elsewhere. In view of the above discussion, we hold that the learned single judge of the High Court committed grave error by interfering with the order passed by the tribunal for payment of back-wages, ignoring that the charges leveled against the appellant were frivolous, and the inquiry was held in a gross violation of the rules of general justice. And the result, the appeal is allowed, the immune order set aside, and the order passed by the tribunal is restored. The management shall be full back-wages to the appellant within 4 months from the date of receipt of copy of this order, filling which it shall have to be interest at the rate of 9% per annum from the date of appellant suspension till the date of actual reinstatement. It is also made clear that in the event of non-compliance with this order, the management shall make itself liable to be punished under the Contempt of the Court Act 1971.
Yes.
The case level against the accused, in this case also it was frivolous, and accordingly the tribunal granted the back-wages, which was upheld by the Supreme Court in this case. Next, lordship. 2019, 17 SCC.
17.
17. Page 184. Relevant paragraph 10, 11, and 12. Page 184.
Pardon? 2019, 17. Yes, wait. Anyhow, read it, read it.
Lordship.
What, 10, 11, and 12?
Yes, I'm reading paragraph 10.
10, okay.
Several judgments of this court have laid down the principle pertaining to the ground of back-wages. And see, in Hindustan, then works, a three-bench judge of this court, educated under criterion for ground of back-wages, where a termination has been held to be illegal. The appellant in that case was a private limited company with the industrial unit. The labor court held that the reinstatement of employees by the appellant was not a bona fide and awarded full back-wages to the employees, which was challenged before the Supreme Court. This court made the following observation. It is no more open to debate that in the field of industrial jurisprudence, a declaration can be given that the termination of a service is met and the workman continues to be in service. extracted of common law doctrine that contract of a personal service cannot be specifically enforced, or the doctrine of mitigation of damages does not count in this branch of law. The relief of reinstatement with continuity of service can be granted where termination.
Mr. Wati, just give me 2 minutes, okay? Yes,
Yes. I continue, Lordship.
you are reading para 10, no, correct?
Para 10.
Ah. Yes, yes.
Yes, Lordship got the judgment.
I have a photocopy.
Okay, para 10, Lordship.
Yes.
Clause 9, the word starts from now, the relief, after 5-6 lines. The relief of a reinstatement. Para 10,
Yes, yes.
the relief of reinstatement with continuity of service can be granted whether termination of service is found to be invalid. It would mean that the employer has taken away illegally the right to work of the workman contrary to the relevant law or in breach of contract and simultaneously deprive the workman of his earning. If thus the employer is found to be in the wrong, as a result of which the workman is directed to be reinstated, the employer could not shirk his responsibility of paying the wages which the workman has been deprived of by the illegal or invalid action of the employer. Speaking realistically, Lord, where termination of service is questioned as invalid or illegal, and the workman has to go through the gamut of litigation, his capacity to sustain himself throughout the protracted litigation is itself such an awesome factor that he may not survive to see the day when relief is granted. More so, in our system where the law provides daily has become step 5. If after such a protracted time and the energy consuming litigation during which the period the workman just sustained himself, ultimately he is to be told that Two, he will be reinstated. He will be denied the back wages, which would be due to him. The workman would be subjected to a sort of penalty for no fault of his, and it is wholly undeserved. Ordinarily, therefore, a fallback which is except to the extent he was gainful employed during the enforced idleness. That is the normal role. Any other view ought to be a premium on the unwarranted litigative activity after termination is motivated as in his case this to resist the workman's demand for revisions of wages. The termination may well amount to unfair labor practice. And such circumstances, reinstatement being the normal rule, it should be followed with fallback wages. Here in this case, it's a dismissal, Lordship. But in my case, it was suspension, and suspension was revoked. In view of
What is the fact of this case? What is the fact of this case?
Lordship, towards the facts, I'm just relying on the relevant portion
Yes.
about payment of
No,
back wages.
what is the fact?
Lordship, fact,
Any idea?
fact is
Whether
that-
actually in this judgment the fact is also reflected?
Yes, Lordship.
Let us see the facts.
Before that, Lordship, may I continue to paragraph 11?
Yes.
Para 11?
Yes. Yes.
The good further clarified that while payment of fallback wages would be the normal role, there can be no departure from it where necessary circumstances have been established. In the very nature of things, there cannot be a straight jacket formula for awarding relief of back wages. So it is the court to decide, taking into consideration of facts and circumstances of a particular case. All relevant consideration will enter the verdict. More or less, it would be a motion addressed to the discretion of the tribunal. Fallback wages would be the normal role, and the party objecting to it must establish circumstances necessitating departure. At that stage, the tribunal will exercise its discretion, giving in view all the relevant circumstances. But the discretion must be exercised in a judicial and judicious manner. The reason for exercising discretion must be cogent and convincing, and must appear on the face of the record. When it is said that something is to be done within the discretion of the authority, that something is to be done according to the rules of reason and justice, according to law and not humor. It is not to be arbitrary, vague, and fanciful, but legal and regular. Taking note of the financial problem of the appellant company, the court granted compensation to the extent of 70% of that which is the principle laid down in so has been followed by other decisions of this court. As far as the facts is concerned, Lordship, may I read from paragraph 1?
Read your 12 also. You were relying on 12 also.
Yes, Lordship.
Yes. Read your 12 also.
12, Lordship. In so case, the termination of the service of the appellant was held to be in contravention of Section so of the Industrial Dispute Act by the Labor Court, but appellant were denied the payment of back wages. In appeal, a three-bench judge of this court observed, plain common sense dictates that the removal of an order terminating the service of a workman must ordinarily lead to reinstatement of service of the workman. It is as if the order has never been, and so it must ordinarily lead to back wages too. But there may be exceptional circumstances which make it impossible or wholly inequitable. Vis-a-vis the employer and the workman to direct reinstatement with fallback wages. For instance, the industry might have closed down or might be in severe financial doldrums. The workman concerned might have secured better or other employment elsewhere, and so on. In such situations, there is a vestige of discretion left in the court to make appropriate consequential orders. The court may deny the relief of reinstatement where reinstatement is impossible because the industry has closed down. The court may deny the relief of the award of fallback wages where that would place an impossible burden on the employee. In such and other exceptional cases, the court may mold the relief, but ordinarily, the relief to be awarded must be reinstatement with fallback wages. That relief must be awarded where no special impediments in way of awarding the relief is clearly shown. True, occasionally hardship may be caused to the employer, but we must remember that more often than not, comparatively far greater hardship is certain to be caused to the workman if the relief is denied than to the employer if relief is granted.
Okay, any more?
Another judgment, Lordship.
This is, I think you, on your reinstatement, the deficit in payment of pension, you are actually asking that only in your petition,
Yes.
that you should be paid full salary
During the intervention.
during the period of
suspension,
not only the subsistence allowance,
all
but your subsistence allowance plus the salary which you were entitled.
Yes, nothing more. Lordship. Those other service benefits, promotion, seniority, nothing.
Yes, what is your other?
Another judgment, Lordship, is reported in the year 1994 to ECC.
1994
to ECC.
to SCC
433.
433.
This is also short judgment, Lordship. 1.5 page.
Your judgments are all very short with with many paragraphs.
1.5 page only, Lordship.
This is this is SSC 1994. Correct.
84.
SSC 1984. Okay. 1980. SSC 1984. Para.
Short judgment, 1.5, merit the whole judgment, Lordship.
Okay.
Paragraph 1. This appeal by special leave arises from a judgment of the High Court of Allahabad confirming the decision of the district judge in appeal reversing the decree passed by the trial court in favor of the appellant. The appellant was working as a permanent upper division clerk in the defense account department at the relevant time. It appears that one Su was wanted in a Gauhati case. On 14/5/62, about 4, the investigating officer received information that Suyesu was present in the premises in possession of the present appellant. And this information led to search of the premises occupied by him. The search and the consequent seizure led to the prosecution of the appellant for two distinct offenses. One under Section Suyesu of Indian Arms Act and another under Section 5 of the Indian Suyesu Act. Pending the investigation, Evelyn was suspended from service with effect from 14 May 1962, the order having been passed on May 5th, 1962. The order of suspension simultaneously provided that Evelyn would be entitled to true subsistence allowance equal to leave salary, which he would have drawn had been on leave on half pay together with the admissible dearness allowance. Evelyn was tried in the court of magistrates, first class Suyesu, for the offense under Section Suyesu and convicted and sentenced to severe imprisonment for a period of 1.5 years as per the judgment dated September 15, 1964. The conviction led to order dismissing the Evelyn from service, effective from October 31, 1964. Evelyn preferred in appeal against his conviction and sentence. The appeal was allowed as per the judgment dated October 31st, 1964, and Evelyn was held not guilty of the offense with which he was charged, and he was acquitted. On being acquitted, Evelyn was reinstated in service effective from September 3, 1965. While ordering reinstatement in service, the concerned authority was required to decide how the period of suspension should be treated. The question was to be decided in the light of the provisions contained under Article 193 of the Civil Service Regulation. The concerned authority divided the period of suspension of the Evelyn into two parts, the first being from May 14, 1962 to 31st October 1964, when Evelyn was acquitted, and second being from October 31st, 1964 to September 3rd, 1965, when he was reinstated in service. With regard to the latter part, the concerned authority directed the payment of full salary after giving credit for suspension allowance that was drawn by him, and there is no dispute between the parties about it. The question then remained with regard to the period from May 4, 1962 to October 31st, 1964, that is the period of suspension. For this period, the concerned authority was of the opinion that the appellant could not be said to be fully exonerated, and therefore a direction was given that the appellant should be given 3/4 of his salary for the period of suspension. The consequences was that for the affirmation period, 1/4 of his salary was not paid to the appellant. The appellant filed suit number so in the court of second civil judge so against the Union of India, contending that as he was never hauled up for departmental inquiry and was suspended only on the ground that the criminal charges was laid against him and pending the trial of the offense, and therefore Article 193 would not be affected, and accordingly it was not open to the authority concerned to deny him full salary for the period of suspension. Alternatively, it was contended that in the circumstances of the case, he was deemed to have been fully exonerated, and therefore also the order withholding 1/4 of the salary was not sustainable. After all this elaborate pleadings and 15 years of litigation, the claim made in the suit was ridiculously low in the amount of restitution. Number 4, the learned judge accepted the case of the plaintiff appellant and decreed the suit with the cause. Surprisingly, too not unusual, this is for this voluntary sum, and some the Union of India carried the matter in e-bill. We find it difficult to appreciate this litigious attitude against a clerk in the lower echelon of service, more so when no principle was involved. It may be stated that the Union India wanted the court to consider the true impact and scope of Article 193, and therefore the bill may have been preferred. The learned district judge was of the opinion that in the circumstances of the case, the appellant could not be said to be fully exonerated and accordingly reversed the judgment and decree of the trial court and dismissed the suit. After an unsuccessful appeal to the High Court, the appellant has filed this appeal by special leave petition. The appellant was suspended in 1962, and we are now in 1983, when the appellant braced for degree of so. During the passage of time, the purchasing power of this amount must have been considerably reduced by now. Mr. Suinso, Learned Counsel Goda, appellant wanted us to examine the scope and embed of Article 193, and Mr. Suinso, counsel for the Union India, was equally keen on the other side to do the same thing. We steered clear of both. The appellant was a permanent UDC who has already retired on superannuation and must receive a measure of socio-economic justice. Giving in view that the fact of the case that the appellant was never hauled up for the departmental inquiry, that he was prosecuted and has been ultimately acquitted, and on being acquitted, he was reinstated and was paid full salary for the period commencing from his acquittal. And further, that even for a period in question, the concerned authority has not held that the suspension was fully justified because 3/4 of the salary is ordered to be paid. We have the opinion that the approach of the trial court was correct and on SLM. The learned trial judge, on appreciation of the facts, found that this is a case in which the full amount of salary should have been paid to the appellant on his reinstatement for the entire period. We accept that as the correct approach. We accordingly allow this appeal, set aside the judgment of First Appellate Court as well as the High Court, and restore the want of trial court with this modification.
Mr. Moore, Mr. Wati,
Yes.
Whether in your case any departmental inquiry was held?
Yes.
It was held.
Held, and no charge was proof. I preferred yesterday, Lordship. The report of the inquiry officer, I referred to yesterday, Lordship.
Okay.
It is enclosed in the writ petition.
So actually, the inquiry officer
did not found any.
That was accepted by the disciplinary authority.
Yes.
Okay. Yes.
So last judgment. Taking the worst situation, Lordship.
What is your worst situation?
Because in most of the judgments, the Supreme Court as well as this honorable court have directed
You were paid. The first you were paid how much of subsistence allowance?
50%.
50%.
Yes.
Thereafter, it was increased to 75%.
Government affidavit for a moment, Lordship.
Yes.
The affidavit filed by the state at page.
Yes, wait, let us.
Lordship, page 4, paragraph 9.
Affidavit of the state.
Yes.
Yes, page
4.
Page 4.
Paragraph 9.
Page 4, paragraph 9.
Subpara, second subpara.
That during
the period of his suspension with effect from 28/12/2013, he was entitled to draw subsistence allowance of 50% of his pay, and allowances which was further enhanced to 75% with effect from 7 August 2019. As for fundamental rules, FR 53. So, Lordship, my last submission.
Yes, yes.
To my last submission, Lordship, I'd like to place FR 54P. FR 54.
FR. Where is that, FR? Fifty-four B.
Yes.
FR 54, just with FR.
Sub rule 2.
Just with FR.
Sub rule 2, Lordship.
Notwithstanding, is it?
Yes.
Notwithstanding anything contained in
Yes,
Rule
Lordship,
53.
yes. 54P, clause 2. May I read, Lordship? Lordship, I'll skip that one, Lordship.
Yeah.
Clause 3.
Clause 3.
Yes.
Just with FR 54B. 54B, clause 3.
Yes.
Yes.
May I read, Lordship?
Yes.
Where the authority competent to order reinstatement is of the opinion that the suspension was wholly unjustified, the government servant shall subject to provision of sub-rule 8, repeat full pay and allowances to which he would have been entitled had he not been suspended. In
What
the
is-
appeal order,
What is sub-rule 8?
sub-rule 8, Lordship, next speech, the payment of allowances under sub-rule 2.
The payment of allowances under sub-rule 2, sub-rule 3
Yes.
shall be subject to all other conditions under which such allowances are admissible.
In the appeal order, Lordship, the respondent authorities stated that suspension order is justified.
Is?
Justified.
Okay.
Suspension is justified. I'm challenging that appeal order.
Yes.
So once the court, in the event court comes to conclusion that it is unjustified, suspension order is unjustified, then
No,
this
court has not given any observation on suspension.
no,
The
the
court,
appeal
the
order
court has
states-
only, the court has only acquitted.
No, Lordship, this court, I mean, if in the event this court
Okay,
arrive to a conclusion that the suspension is not justified,
okay.
then my case covered by FR 54, B clause 3.
Okay, so where is that
Lordship,
citation?
we kindly turn to impugn order.
Impugnable.
Yes. I'm challenging this what?
Page
Page 45.
45 of the petition.
Yes.
Forty-five.
Yes.
Yes.
Number 1, Lordship. First, second, third, fourth paragraph.
Hmm.
This is the impugn order, Lordship. Since its acquittal in the criminal case is on benefit of doubt and not honorably acquitted, his suspension is justified suspension. I am challenging this one. I am saying it is not justified. Therefore,
Yes, wait. Okay.
Therefore, my humble submission, Lordship, since it is not justified, my case is covered by FR 54, B clause 3.
Let us read the FR 54B once again. Where the authority competent to order such reinstatement is of the opinion that suspension was wholly unjustified, the government servant shall, subject to the provision, be paid the full pay and allowance to which he would have been entitled had he not been suspended.
Yes.
Wholly unjustified. Suspension was ordered to the government servant.
State authorities are saying that it is justified, which is under challenge, this writ petition.
So we are going back to the
Yes.
judgment passed by the trial court.
Yes, Lordship. Why it is unjustified, Lordship? Suspension was in view of restriction of the criminal case. Unequivocal, Lordship, reinstated. Therefore, how the suspension should be justified suspension, Lordship? None of the charges.
The submission which you were just making, what did you say?
Suspension.
Yes.
Petitioner was placed under suspension in view of registration of the frivolous criminal case.
Okay.
Trial was conducted, Lordship. No evidence was found. Accordingly, he was acquitted. Therefore, on reinstatement is eligible for full pay and allowances. In terms of FR 54 clause 3, B clause 3. Because the suspension cannot be termed as a justified suspension in view of the acquittal of the accused from the criminal case. Therefore, the reason given in the imbued order as regards the denial of full pay and allowances on the ground of the accused was acquitted on benefit of doubt, and the suspension is justified.
Okay.
Can I stand the test of law, Lordship? Therefore, the imbued order is liable to citizen quash, and my prayer is to direct the authorities to be full pay and allowances during the suspension period. Much obliged.
Mr. KV,
Lordship,
what is your further submission?
Lordship, Lordship, I'd like to place suit to authority, Lordship.
Yes,
But
yes.
before that, what the Supreme Court says about trial court and the case of the prosecution is not supported by the witnesses. But before that, whether shall I take my lord to the determination of point,
You make it convenient. You make it convenient as to how you will submit.
Lordship? Then allow me to take my lord to the petition, Lordship.
Petition.
Yes, page 38.
Okay.
Read petition.
Just wait. Page 38.
Lordship.
Yes.
Lordship, allow me to read, Lordship. With regard to the second point for determination,
That is whether the accused person on 28 so and so in furtherance of common intention attempted to murder three so and so and thereby committed an offense punishable under so and so section APC. I've gone through the material evidence on record and found that in the FIR, the informant had alleged that while they resisted the accused person from stealing firewood from the Kanyatokbi gown, the accused Taka Momba opened fire by aiming at the complainant and his friend and tried to kill them. Lordship here, but interestingly, the learned trial court says, but interestingly, in course of examination in chief, complainant nor any of the PWs of the village have not deposed anything like the allegation of FIR. In view of this fact and circumstances, I am of the considered opinion that prosecution has failed to prove the second point for determination beyond all reasonable doubt. Then the next paragraph, Lordship, with regard to the third point for determination, whether the accused person on so-and-so date at so-and-so possessed 1.22 pistol along with one magazine, 20 so-and-so, and thereby committed an offense punishable under so-and-so, I have found that in the FIR, the informant had alleged that the accused person, Taka Momba, had opened fire to the informant and tried to kill him. But, again here, during his examination in chief, the complainant has not alleged anything about the firing from the firearms to him by the accused person, nor he was the seizure witness. Apart from this, no PWs have alleged about the using of firearms by the accused person. Although the PW7 has stated about examination of firearms.
No, Mr. KB.
Yes.
We are actually not taking up an appeal. We are not taking up an appeal.
No, Lordship. But I'm just.
So I think you just address this court. If you have any objection to the grant of the relief sought by the petitioner.
Lordship, yes, I'm coming to that.
Yes.
That was the background. Now the picture we have seen is that the prosecution witnesses failed to support the prosecution case, Lordship.
Yes.
That is my. Lordship, firstly, Lordship, firstly, 2013, one.
Just wait.
The first one, Lordship, is 2013, one SEC.
2013 one SEC. Correct.
Yes, 598, Lordship.
Yes. Just wait. 2013 one SEC 598. Paragraph
26, Lordship.
Paragraph 26.
Lordship.
Okay.
26.
26.
Allow me to read the whole paragraph, Lordship. Not very long.
Why not 24, 25, 26?
Oh, Lordship, sure.
Because actually it talks about honorable acquittal.
Lordship. May I, Lordship?
Yes, please. Yes.
The meaning of the expression honorable acquittal came up for consideration before this court in RBI versus Bhopal Singh Panchal. In that case, this court has considered the impact of Regulation 46 Clause 4 dealing with honorable acquittal by a criminal court on the disciplinary proceedings. In that context, this court held that the mere acquittal does not entitle an employee to reinstatement in service.
The acquittal it was held has to be honorable. The expression honorable acquittal, acquitted of blame, fully exonerated are unknown to the Code of Criminal Procedure or the Penal Code, which are coined by judicial pronouncements. It is difficult to define precisely what is meant by the expression honorably acquitted. When the accused is acquitted after full consideration of prosecution evidence and that the prosecution has miserably failed to prove the charges leveled against the accused, it can possibly say that the accused was honorably acquitted. In paragraph 25, in
Yes.
RP Kapoor versus Union of India, it was held that even in the case of acquittal, departmental proceedings may follow where the acquittal is other than honorable. In state of Assam versus Argava, Raja so and so, this court quoted with approval the views expressed by Lord Williams so and so, which is as follows. So and so. The expression honorably acquitted is one which is unknown to courts of justice. Apparently, it is a form of order used in courts martial and other extrajudicial tribunals. We said in our judgment that we accepted the explanation given by the appellant, believe it to be true, and considered that it ought to have been accepted by the government authorities and by the magistrate. Further, we decided the appellant had not misappropriated the monies referred to in the charge. It is thus clear that the effect of our judgment was that the appellant was acquitted as fully and completely as it was possible for him to be acquitted. Presumably, this is equivalent to what government authorities term honorably acquitted. Paragraph 26, Lordship. As we have already indicated, in the absence of any provision in the service rules for reinstatement, if an employee is honorably acquitted by a criminal court, no right is conferred on the employee to claim any benefit, including reinstatement. Reason is that the standard of proof required for holding a person guilty by a criminal court and the inquiry conducted by way of disciplinary proceedings entirely different. In a criminal case, the onus of establishing the guilt of accused is on the prosecution, and if it fails to establish the guilt beyond reasonable doubt, the accused is assumed to be innocent. It is settled law that the strict burden of proof required to establish guilt in a criminal court is not required in a disciplinary proceeding, and preponderance of probabilities is sufficient. Lordship, the next sentence will be important, Lordship. There may be cases where a person is acquitted for technical reasons or the prosecution giving up other witnesses since few of the other witnesses turned hostile, etc. Lordship. In the case on hand, the prosecution did not take steps to examine many of the crucial witnesses on the ground that the complainant and his wife turned hostile. The court therefore acquitted the accused, giving the benefit of doubt, Lordship. We are not prepared to say that in the instance case, the respondent was honorably acquitted by the criminal court. Lordship, this reference I'm trying to cite when I cited that, read that to the point of determination, Lordship.
Okay.
And then, let me continue. And even if it is so, Lordship, he is not entitled to claim reinstatement since the Tamil Nadu service rules do not provide so, Lordship. So that is one, Lordship. Then,
Here, you yourself, you have reinstated the petitioner.
Lordship.
Even before the criminal trial was over,
Lordship.
the department, the government was so generous that you had actually taken back the petitioner and
Yes.
actually reinstated him in service.
But subject to the culmination of the
Subject to the outcome of the criminal case.
Lordship.
That's all. Okay.
But
okay.
here, what I'm trying to say is the prosecution case has not been supported by the witness. In such case,
Okay.
it cannot be said that it's an honorable acquittal. What
Okay,
I'm trying
that
to
is
say,
your
Lordship.
submission. That is your submission. We keep
And the
note of
other
that.
one, Lordship, 2004, one
Yes.
CC 121, Lordship.
Just wait, Mr. KV, 2000,
Shall
2004, 1 SCC 121.
Lordship, when the case is for the fault of the accused or the what the Supreme Court says
Which
on the
para,
back.
KV? Which para?
For Lordship.
Para 4.
Yes, Lordship.
Okay. Yes.
On a careful.
This para 4.
Lordship.
Okay. Yes, please.
On a careful consideration of the matter and the materials on record, including the judgment and others brought to our notice, we are of the view that it is well accepted that an order rejecting a special leave petition at the threshold without detailed reasons, therefore does not constitute any declaration of law by this court or constitute a binding precedent. Per contra, the decision relied upon by the appellant is one on merits and for reasons specifically recorded. Therefore, it operates as a binding precedent as well. On going through the same, we are in respectful agreement with the view taken in Ranch Chot GG. If prosecution which ultimately resulted in acquittal of the person concerned at the behest of or by the department itself, perhaps different consideration may arise. On the other hand, if as a citizen the employee or a public servant got involved in the criminal case, and if after initial conviction by the trial court he gets acquittal on appeal, subsequently the department cannot in any manner be found fault with for having kept him out of service, since the law obliges a person convicted of an offense to be kept out and not to be retained on service. Consequently, the reason given in the decision relied upon for the appellant are not only convincing but are in consonance with reasonableness as well. Though taken to that part of the hard order directing reinstatement cannot be sustained and the respondent has to be reinstated in service for the reason that the earlier discharge was on account of those criminal proceedings and conviction only. The appellants are well within their rights to deny back wages to the respondent for the period he was not in service. The appellant cannot be made liable to pay for the period for which they could not avail of the service of the respondent. The High Court, in our view, committed a grave error in allowing back wages also, without adverting to all such relevant aspect and consideration. Consequently, the order of the High Court, insofar as it is directed payment of back wages is liable to be and is hereby set aside, Lordship.
But here he was discharged from service.
Yes, Lordship.
He was discharged from service.
Lordship.
The present case.
Yes.
In the present case.
Lordship.
He was only suspended.
Lordship.
Because of the criminal case registered against the petitioner.
Lordship.
But in the interim, the government had reinstated him.
Lordship.
Despite the criminal case not being attaining this conclusion.
Lordship, yes.
And what was the word used by the government in the impugn order? That they will allow to continue to pay the subsistence allowance till the culmination of the criminal case.
Lordship.
Meaning thereby that if you take it other way around,
Lordship.
that once actually he is honorably acquitted,
Lordship.
he will be paid the full salary.
Lordship.
So the only dispute now is actually whether he was honorably acquitted or he was acquitted on benefit of doubt.
Lordship.
So this court has to decide on that.
Lordship. Lordship.
Yes, so what is?
Lordship, that's all.
Okay.
Obliged.
I had Mr. Wati Jamir. learned counsel for the petitioner, and Mr. K. Angami, the learned senior government advocate for the state respondents. So the parties are length, judgment reserved.
Bless you.
You get this all okay. You keep it here. Where is that? Okay. This also you staple it, okay? You staple it and keep it here. Okay. No. Don't give now. After I read only, I will like while reading the judgment, I'll tell the library to. Okay, you staple this also.
For orders, item number 50.
Yes.
Lordship. Lordship, this honorable court, by order dated 3/4/2023, directed the appellant company to take steps through registered post 80, and the service is completed, Lordship.
All the respondents. So how many respondents are there?
I'm for respondent number 1 to 5.
You're for 1 to 5, Mr. Ben Sharma?
Lordship.
And ma'am? 6.
6 and 7.
So all the respondents are represented.
Yes, Lordship.
So will listen for hearing?
Lordship, subject to the deposit of 50%, appeal may be admitted for hearing.
That order is there.
No order. Only service of notice is completed today.
Any application filed for suspension?
Yes, it is filed.
Yes. Where is that?
Stay petition quota, sir.
Where is that?
Lordship, we have filed 2 IA. One for delay condonation of 126 days.
Whether delay condoned?
Not
No,
yet,
Lordship.
not yet.
Oh.
Today only service of notice completed. Lordship.
Okay. So IA 200 is for delay.
Yes, Lordship.
So your any objection to the delay?
Lordship, I have an objection, but however, subject to the deposit of 50%, appeal may be admitted for hearing. Otherwise, I shall file objection.
No, that actually you cannot impose that on the court. That the court will
No,
see.
Lordship, I'm just.
Whether you have any.
I have an
objection?
objection, Lordship.
You have objection?
Yes, Lordship.
Then in that case, your 50% will get delayed. So you choose.
Lordship,
You choose
it
which
is-
is the best option for you.
No, Lordship,
Either to get.
Lordship, it has appeared that even after filing of the return objection, delay condone, then also they are liable to pay 50% of the awarded amount before disposal of the appeal.
No, that's why I'm saying.
That is why I'm just praying, if the same thing is done today, then I have no objection.
No. We will come to the other IA
Lordship.
for suspension.
Yes, Lordship.
Immediate to the disposal of this IA for condonation.
Yes, Lordship.
So it is up to you whether you want to keep this IA pending, or whether you want to you will be generous to say that you have no objection, and let
Lordship,
the court.
I may be allowed to 3 weeks time to file objection.
Okay. Because you may actually like by filing all this, of course, I have nothing to say, but maybe you may be like delaying the payment. Anyhow, it's up to you. I have nothing to say. Mr. B.N. Sharma, the Learned Counsel for the opposite party number 1 to 5,
Yes, Lordship.
submits that he may be allowed 3 weeks' time to file objection to the application seeking for continuation of delay. You will also file, ma'am. Prayer is allowed. Listed after 3 weeks. Yes, just before that, I think all the parties are present. This is the first step. Heard Mr. So-and-so. That should precede that order. Okay, heard Mr. So-and-so, the Learned Counsel for the applicant, Mr. B.N. Sharma, the Learned Counsel for the respondent number 1 to 5, and MS so-and-so, the Learned Counsel for the respondent number 6 and 7. Okay, then continue with that. Okay, listed after 3 weeks.
Much obliged.
Item number 51.
Item number?
Lordship, as per the last order dated 12/1/23, service notice is served upon all the respondents.
As per 15?
12/1/2023.
12/1/2023. 12/1/2023. 12/1, yes. Okay, except for service of. So you have taken steps.
Yes, Lordship.
Who are the respondents? Let us see.
The State of Nagaland, the Chumukidima Town Council, the Additional Deputy Commissioner,
State is present.
Lordship.
Chumukidima Town Council.
Lordship.
Additional Deputy. You are for Additional Deputy Commissioner also?
Yes, Lordship.
Yes.
Yes, Lordship.
Except Dimapur Town Council.
Yes,
Chumukidima Town Council. So 1 and 3 is represented by Mr. V. Jimami.
Lordship.
Correct.
Lordship.
And 2. Why 2 is impleaded?
Yes, Lordship.
Why 2 is impleaded? Respondent number 2.
Actually, it is the respondent number 2 who is obstructing the safe work.
Oh.
So they have completed the respondent number 2.
What work is it?
Lordship,
Lordship, the petitioner applied for installation, erection of 5 number of unipole measuring 20 into 10 feet, having pole length of 20 feet with RCC, foundation based in and around the Chumukidima town, Nagaland before the respondent number 3. The writ petitioner was allowed to erect installed 5 numbers of unipoles along the NH29 within the jurisdiction of the Chumukidima Town Council. However, by the imprint order dated 19/12/22, after the petitioner had met
Who has issued the impugn order? Who has issued the impugn order? Where is that impugn order? Madam, where is that impugn order?
annexure, kindly come to page number 20, annexure 4.
Page number?
Page number 20.
20.
Annexure 4. By the Additional Deputy Commissioner.
You are supposed to take note, represent this too also. He is the ADC administrator.
Lordship.
So you represent him. ADC, because actually, effectively, we don't have any, there's a town council. These are all run by ADCs and all this DCs as administrators.
Lordship.
So if there was a effective town council functioning, that may have been a different issue. But now it is only the this administration
Lordship.
who are functioning as the administrator. So you represent 1, 2, 3. You
Lordship.
get instructions, okay?
Lordship.
Okay. Mr. Vijmomi, the learned government advocate, 6 for 3 weeks' time to receive instructions from the respondent number 1, 2, and 3. Prayer is allowed, listed up to 3 weeks. Okay?
Item number 52.
Yes, Mr. Nangami.
May I please, my lord?
Yes.
Lordship, I have instruction to appear for respondent number 1.
One.
Lordship. Some time may be granted, your lordship, to get the necessary instruction.
What about 2, 3, 4, 5?
No, your lordship, I don't have instruction to appear on their behalf, your lordship.
No, but the government advocate should appear.
Yes, lordship, but your lordship, whether the notice upon these 2, 3, 4, and 5 has been completed on your lordship, that is, because it's in the order column.
Mr. Nangami.
Lordship,
See, whenever the government advocate appears,
lordship,
unlike a notice served on a private individual,
lordship.
we cannot say whether notice has been served on the government respondents, because actually it is the government advocate who appears. Like the normal writ petitions.
Lordship.
Where is
Oh, lordship,
Socrates?
Mr. KV.
Yes, Mr. Kiwi. You are government advocate only for some departments? Or you are government advocate for all the government departments?
For all.
Who is handling this case? Let us see the last order. Let us see whether any order has been passed. Is it coming up for the first time?
After the motion, your lordship, I think it's coming for the first time.
Oh, this is
This is
contempt.
contempt
I'm
petition,
sorry,
your
I thought
lordship.
it was a writ petition.
Yes.
So what do we do now? Only one is present.
Lordship, and therefore, for the rest of the respondent, I don't know whether notice has already been completed on your lordship, because this is in the order column.
Service of notice upon respondent 1 to 4. Issues and so return service report is awaited.
Lordship.
Yes, and it is very recent, no?
Yes, my lord.
Awaiting service, Mr. K. Angami.
And Angami, your lordship.
And Angami, I'm sorry. The learned senior government advocate appears on behalf of the respondent number 1. Service upon respondent number 2, 3, 4, and 5 awaited. Listed up to 3 weeks.
Deeply obliged, my lord.
Much obliged.
It's okay.
Mr. Nangami, the Learned Senior Government Advocate, appears for the respondent number 1. Office note dated 12/5/2023 shows that return service report awaited in respect of respondent number 2, 3, 4, and 5. Awaiting service report listed after 3 weeks.
Deeply obliged, my lord. Item number 54.
Lordship, here we have received instruction. My senior TB Jamir will be appearing for respondent number 4.
The respondent 4.
That is Lokayukta.
Very good. 4. For the state, KB.
So, Lordship, 3 week time will be granted. In the meantime, we will be filing our Vakalat Nama
An affidavit.
and affidavit.
Mr. Your good name?
I Jamir.
I Jamir. The Learned Council for the respondent number 4 submits that he may be allowed 3 weeks' time to file power and affidavit in opposition. Prayer is allowed, listed after 3 weeks.
Obliged.
Yes.
Item number 55.
Next, Lordship.
Yes, Mr.
Lordship, I have
Seko.
instructions to appear for respondent number 6, the private respondent. Respondent number 6.
What about the other respondents?
Your Lordship, I'm for respondent 1 to 5. The state.
1 to 5.
Yes, Your Lordship. State is here to file affidavit, Your Lordship.
Lordship, may I kindly grant 3 weeks' time to file my affidavit as well as my power?
Mr. Fuseko, the Learned Council,
Respondent number 6.
appears for the respondent number 6 and submits that he may be allowed 3 weeks' time to file power and the affidavit in opposition.
Lordship.
Stop. MSEIME also seeks for 3 weeks' time to file affidavit in opposition on behalf of the state respondents. Where is allowed, listed after 3 weeks.
Lordship, there's an interim.
The interim order passed earlier shall continue till the next return.
For unlisted motion, AP 14 of 2023.
May it please, my lord.
Yes, Mr. Singhal.
Lordship, the present group of anticipated bail applications, Lordship, are all connected to the anticipated bail application which was heard at length yesterday, my lord, arising out of the same FIR, and they are all members of the same organization. They are holding different positions within the Naka Club. My lord, when the anticipated bail 7 of 2023 was moved, which was disposed yesterday, at the stage of motion, my lord, a conditional order was passed. If my lord can also pass similar conditional orders in this present application. I have annexed the order at page 95, annexure V1.
Where's the FIR?
FIR page 70, my lord.
71.
70, my lord. 71 is the type copy, my lord. Annexure R.
What is the case registered?
Case was registered at North Police Station, my lord.
What case
as
number?
Case number 21.
What is it stated?
It is stated in this, written on the body of the FIR, my lord. I have also stated in my petition as well, but
Yes,
in
in your petition, in paragraph.
my lord, at page 17.
At page
17, my lord. Immediately below the important portion, my lord. Page 17.
Yes.
Accordingly, a case was
Yes.
registered being Kohima North PS case number 21/2023 under sections 427, 457, 120B, and 34
Pardon,
IPC.
Mr. Santi Amar, the learned counsel for the applicant. This application has been filed under section 438 of the Criminal Procedure Code, 1973, praying for pre-arrest bail. This application has been filed by the applicant, correct? You just read. We have mentioned that applicant, no? Yeah. Praying for pre-arrest bill. In connection with Kohima North PS case number 0021/2023 under section 427, 457, 120B and 34 IPC. Mr. V. Jimomi, the learned public prosecutor, shall produce the case diary on a week's time.
A week's time, Lord.
Yes, give a date.
On 15th.
Week, shall produce the case diary on 15/6/2023. Stop, new para. The applicant no. In the interim, pre-arrest bail is granted to the application with a condition that the applicant shall appear before the police within
The investigating officer, my lord, within a period of 5 days, my lord.
Within a period of 5 days from today.
My lord.
Stop. On the appearance of the applicant before the police, he shall be allowed to go on bail on executing a bail bond of rupees
20,000, my lord, as was granted in
20,000.
the other case.
Stop. The interim bail is also considered under the following conditions. That the number one, that the applicant shall appear before the police, before the OC, not PS,
My lord, before the investigating officer,
before
my
the
lord.
OC, not PS Kohima, / investigating officer of the case, IU of the case. Where does he resides? As and when summoned. As and
He
when summoned.
resides in Kohima, my lord.
Where?
At Chizami.
Chizami.
He is a permanent resident of Chizami, my lord.
Chizami is Pek.
Yes, my lord.
Okay. Two,
Only his.
you shall not indulge in similar or same offense with which he is charged. List the application on when? On 15.
On 15.
15? 6/2023. Okay.
Deeply obliged, my
Similar,
lord. Yes, my lord.
similar order with all this anticipated.
Deeply obliged, my
Yes.
lord.
Please, Your Lordship, I'm deeply sorry, Lordship.
What is your deep sorriness?
I forgot to continue my interim, item number 54.
Item 54.
Yes.
Okay, item 54. Okay, the interim order passed earlier shall continue till the next returnable date.
Deeply obliged.
Yes.
For hearing, item number 56.
May I please, Your Lordship?
Yes.
Your Lordship, may I be given a week's time to file an additional affidavit, Your Lordship? I wish to place on record some relevant documents.
What is that document?
Your Lordship, in my affidavit, it was stated that the land where the veterinary office was established, it was donated by 4 landowners. The record is like that. And out of the 4 landowners, 2 landowners had sold off their the land. And presently, the office is established on the land donated by 2 landowners. But Your Lordship, it has come to light that the petitioner's land is also part of the land where the office is established. So I wish to place on record that document, Your Lordship.
Okay. Have you filed your affidavit?
Yes, Lordship. I
Yes.
filed.
MSAIME.
Lordship, in persons to the order dated 22/5/2023.
22.
22/5/2023, the last order. Lordship, now the petitioner has filed an affidavit saying that the person has been known wholly, if not his father. Lordship, the present petitioner and the respondent number 4, they are from the same village. So, Lordship, I want to file an affidavit denying this affidavit.
Order dated
22/5/2023.
22/5/2022.
Yes, Lordship. 23.
23.
The last order.
22/5/2023. Okay. Mr. Izzat Kulnu, the learned counsel for the petitioner, MSAIME, the learned government advocate for the state respondents, and Mr. Eli Wabawang, the learned counsel for the respondent number
4.
4. Stop. In terms of the order dated 22/5/2023 passed by this court, Mr. Izzat Kulnu has filed the affidavit. Stop. Mr. Limawabang, the learned counsel for the respondent number 4, submits that he may be allowed to file
rejoinder
to the affidavit filed by the petitioner. Stop. MSAIME also submits that he may be allowed some time to file additional affidavit enclosing certain documents relevant for the case. List the case
After 2 weeks.
after 2 weeks.
Much obliged.
But Mr. Limawaban,
Yes, Lordship.
let us make an endeavor to dispose this case. 2016 matter.
Yes, Lordship.
So I think we should.
Or next date we can.
Yes, we should all make an endeavor to dispose this case. Okay?
Much obliged.
Item number 57.
Yes, Lordship.
Yes.
Lordship, in this case, I'm led by my senior Dali out. But
Okay.
now he's not well since last week. But Lordship, since the matter has been already decided by the larger bench, the issue involved in this case. Lordship, in this case, the issue arose, the issue involved is whether the DB scope we can entertain a appeal against the order passed by the village authority under Rule 31 of the 1937 rules. But on the similar ground, the Justice Survey passed an order saying that under Rule 31, the DB scope have the appellate jurisdiction over the decision passed by the village authority. However, that judgment was the Justice Kodishwar. It extended to that order passed by the Justice Survey. And the matter was referred to the larger bench. Now the larger bench passed an order that under Rule 31, this DB court doesn't have the jurisdiction to sit on appeal against the village authority. That is the order passed in this petition.
Okay.
And the division bench has remanded the matter back to the nurse single judge for disposal of the matter. So the main issue involved in the prisoner petition is already decided. But the Lordship, how the issue arose from the facts, Lordship, I'll take it, Lordship.
No, first tell me, what is your case?
Yes, Lordship.
Let us see what is your case.
Lordship, the case of the petitioner arose out of a judgment passed by the Dibobar village court in a land dispute case. Lordship, the judgment passed by the Dibobar village council is at page number 49.
I hope all the parties are present.
Yes, Lordship.
This is the impugn order?
No. This one is not unchallenged.
This is the
Cause of action.
This is the original order.
Original order passed by the Dibobar village. Against this order, they have submitted an application before the EC to move them. From there, the issue arose.
Okay, so against this order?
Yes, Lordship, the relevant portion.
Yes.
Yes, page 54. This is a decree passed by the village court. This is the last.
Page
last-
54.
Page 54. The last paragraph.
Just wait.
Lordship, got it? The Dibobar village council.
Just
therefore
wait,
resolved to-
just wait. Page 54.
54. In the bottom, the last paragraph.
Yes.
The Dibobar village council therefore resolved to, number one, impose a fine of rupees 15,000 only to Impleadment. Number two, cancel village pata number 22, direct 9/3/2016 standing in the name of the Dolo Po Angami, which was transferred from Kenny Society, shall be reverted to Yashila Jamir. Yashila shall refund rupees 29 lakhs towards the cost of land. Yashila Jamir shall also reimburse rupees 54 lakhs only towards the expenditure incurred by Kenny Society after the land transaction. All the parties are directed to comply to the above stated verdict within 15 days from the date of this.
Oh my God. But whether the village council has the jurisdiction to pass such big amount?
Your Lordship, it happened like this. Your Lordship, this Imgila Chamir, she's a sister of the petitioner number 1, 2, and 3. As your Lordship noted, they are the children of Inai Chamir.
1, 2, and 3.
1, 2, 3. Yes.
1, 2,
1, 2, and 3.
And who is this Yashila
So
Jamir?
Yashila is the
Wife.
mother of petitioner number 1, 2, and 3.
Okay.
She expired during the pendency of this petition.
Okay. Okay. So
It
what
happened
happened?
like this. This Yashila, this Impila Jamir, she took a loan from the private respondent.
Who is Impila Jamir?
Impila Jamir is the sister of petitioner number 1, 2, and 3. The black sheep in the family.
The black sheep.
Yes.
There is always one black sheep.
Yeah,
Impila.
Jamir.
This respondent 7.
Respondent number 7. Lordship.
And who is representing 7?
Lordship, we have taken the ships by Dusty Service also. She's not contesting.
Whether it is deemed served?
Yes, deemed served.
By which order? Let us first see that everything is complete.
Number order dated 12/2/2018.
12/2?
2018.
Twelve to 2018. This is a very old case, huh?
This is a very old case and lots of order, Lordship.
Yes. 2018.
We have served a notice by Dusty Service.
2018. Oh,
2018. Upon respondent number 4 and 7.
Okay. Is the 4 and 7?
4 and 7.
And who are 4 and 7?
4 is the Tomoshi School.
4. At Dubashi.
Yes,
Madam Secretary, you are for 1, 2, 3.
Yes.
1, 2, 3. And yes, ma'am, you are for
5 and 6.
5 and 6, Your Lordship.
5 and
6.
6. So 4 and 7 deemed served. Okay, I think there are many facts involved.
Many facts.
Yes, so let us hear the facts. Let us just give me the gist so that I
Yes,
can
it is.
also understand the case.
It should be happened like this. This respondent number 7.
Okay, 7.
She exhibited a sealed bid with a private respondent. By
To
taking
the private respondent number?
Respondent number
5 and
society.
6.
The society.
5 and 6.
Lordship, 5.
5.
Yeah, secretary of the claim.
Ma'am, you are for 5 and 6. 5 and 6. Okay. Okay, so 7 executed an agreement with 5 and 6.
5 and 6.
Yes.
by taking a loan of rupees 20 lakhs.
20 lakhs, okay.
And in that loan transaction, she has forged a signature of respondent number of the petitioner number 4 and 3. Petitioner number 3 is the youngest brother, and respondent number 4 is the mother.
Okay, so this respondent number 7, by forging the signature of
Respondent number
petitioner 3 and 4,
She
has
took a-
executed an agreement with respondent number 5.
respondent number 5. By,
Yes.
And by submitting the link bata
Okay.
of the dispute lien.
Whether that land butter was genuine.
Link bata was issued by the village authority.
Okay, that is a non-cadastral land.
So, Your Lordship, the present petitioner number 1, 2, and 3. They filed a complaint before the Dipupar village council.
Okay.
The Dipupar village council took up the case. And after trial and evidence, they passed this order.
This order.
Yes.
At page 49.
50, yes, Lordship. Page number.
Okay.
Yes, 49.
49, yes.
So that is the cause of it.
Uh,
Your Lordship, against the order passed by this village authority, Lordship, we come to page number 60.
60.
60. It is an application submitted by the respondent number 5 to the EC Jumugin.
Page 60. Yes.
May I read? To the
Yes.
EC Jumugin, Timor Nagaling. Subject complaint against Dipupar Village Council Chairman Mr. Lanuduchi. With reference to the subject cited above, I have the honor to state that TVC, that is Dipupar Village Council, Chairman Mr. Lanuduchi, with malevolent intention, by misusing his esteemed chair, that means he's the council chairman, has been issuing summon and verdict contradictory to the ownership of the plot of land situated at Ekil Dipupar village. It has been causing hindrance and questioning our credibility without any proof in evidence to substantiate his claim to the ownership of the plot of land which has been legally purchased with proper documents by the Guinea Society. Therefore, we request your kind authority to look into the matter and take any necessary action as the authority may deem fit for the ends of justice and for peaceful enjoyment of the above mentioned plot of land by the
So
Guinea
this complaint letter is against the decision at page 49.
Yes, sir.
Okay.
And it should become the next page. The EC Chamukidima has taken the cognizance of this letter and passed this order. Order dated 30th May 2017. This is impugned the writ petition.
This page 61 is impugned.
This is impugned.
Okay.
Order dated 30th May 2017.
Yes.
Whereas a complaint letter is received from Guinea Society regarding a land dispute between Mrs. Yashila Tamir, wife of late Inai Tamir, resident of Chiki in Guinea Society South Mile, taken up by the Dipupar Village Council. The complainant has alleged that the chairman of Dipupar Village, with malevolent intention, has misused his chair and issued contradictory verdict regarding ownership of a plot of land at Eagle Gibuar village. Lordship, this is important. Therefore, the case is hereby endorsed to Tobashi's Court, Naka Customary Court, under the Office of the Extra Assistant Commissioner, Chumukinima, for dispensation of justice. Under Rule 23 of the 1927 rules, which is not permissible.
And, Mr. Lima, whether the petitioners have accepted the order passed by the village council at page
Yes, Lordship,
40.
yes, Lordship.
They are accepting that.
Lordship may come to, in compliance to the order passed by the Tobashi's Court, Lordship may come to page number 58.
So where is the order passed by Dubashi's court? So as per this order issued by ESC, has the Dubashi's court adjudicated the matter?
They have issued a summon.
They have issued a summon. Let's see the summon.
And Lordship, next is the restraining order. Lordship, similar to the page
Restraining order issued by,
the EC Chumukinima.
which is that order?
Lordship, next page, page 62. Para 1, 2, and 3, all are the
Just wait, just wait.
a very lengthy text. Lordship, is this.
Okay.
Lordship, it's just a one-page order. I mean, we're not to read.
Yes.
The entire fact is disclosive.
Yes.
Whereas an appeal against the Gibuar Village Council, order dated 30 May 2017 of case number so and so, is received from Guinea Society, white letter number nil, dated 31 May 2017. Wherein the Gibuar Village Council has directed Guinea Society to collect the settled amount of rupees 35 lakhs only from the office of the Gibuar Village Council at 10 a.m. on 31st of May 2017 without fail. Further, the society was required to submit all land documents in the event of failure to collect the settled amount and surrender the land documents. The Gibuar Village Council has directed to forfeit all land documents in connection with the said case and issue fresh land documents in favor of Mrs. Yashila Jamir, in that no further correspondence to be entertained. And whereas, as per the complaint received by this office dated 27 May 2017 from Guinea Society, the case was endorsed to Tobashi's Court under the office of the EC Chimugirima, by order number so and so dated 30 May 2017 for dispensation of justice. Subsequently, appeals case number so and so is registered on 31st May 2017 in the DB's Court Chimugirima. They have registered the case. And whereas information is received on the resolution of Gibuar Village Council dated the 1st June 2017, where the Gibuar Village Council directed Guinea Society to take up the
To take the settlement.
Yeah, to take the settled amount of rupees 35,000.
35 lakhs.
35 lakhs, sorry. Only from the office of the Gibuar Village Council within 3 days from the date of issue of this letter. Therefore, as the case is subjudiced pending for court hearing, a restraint order is hereby issued to all parties concerned for strict compliance. Further, the Gibuar Village Council is restrained to exhibit the said order. Non-compliance to this order shall be viewed seriously and attract legal prosecution as provided by law. So, in view of this restraining order, the money which has been deposited by the petitioner's family is still lying in the account of the Gibuar Village Council. And we should come to page number 63.
This restraint order, is it also challenged in the present writ petition?
No.
Okay. Then the next, what happens thereafter?
This is a summon.
Dubashi's court?
The Tobashi's Court.
Where is that?
We should come to page number 63.
63.
After they register the case.
Page 63.
On 31st May, they have registered the case. And on 1st June, they have issued a summon.
This is also impugned.
This is also impugned.
Yes, thereafter what happens?
Yes, Lordship. Lordship, not necessary to read this someone. Lordship will file an objection. The next page, page number 64.
64.
Yes, Lordship.
Yes.
Lordship, Lordship, not necessary to read the entire complaint. Read the relevant portion is para 3, page 64.
Yes.
That at this stage, we feel not necessary to express on the merit of the decision verdict rendered by the village council court. However, our objection petition is confined to the question of jurisdictional competency of the EEC and or the TB court to entertain, hear, and decide any petition while appealing against the verdict decision passed by the village council court. This is the crux of the issue.
Okay. Okay.
And Lordship, page number 67. The same complaint on the same ground we have submitted to the extra assistant commission.
67. Who has submitted this complaint?
The present petitioner. Petitioner number.
Okay. Petitioner has submitted this complaint.
Yes, Lordship.
Okay.
Petition number 4 and 2. Lordship, after we submitted this complaint,
Yes.
yes, Lordship. After we submitted this complaint, the EC Chimokdima, yes, referred the matter to the Deputy Commissioner, Deputy Commissioner Timapur. Deputy Commissioner Timapur examined the matter and passed this impugned letter again, page number 70. This
Page?
letter, page 70. This letter is also impugned in the present.
Page 70.
Yes, Lordship.
This was on reference by EAC.
On reference by EC, EC Timapur has issued this impugned letter.
So this order is also impugned.
Your Lordship, by this letter, the Deputy Commissioner has given the authority to the AC to try the case. Your Lordship, they are weak.
No, but this this order is also impugned.
It's also impugned. Your Lordship, this is only a letter, not a law.
Yes.
To the extra assistant commissioner, Chimokdipa Timapur, subject case number so and so. Reference to the subject, said it above. I am to inform you to take up the issue and dispose of the matter after hearing both the parties from your end. It may be stated that the DB's court has appellate jurisdiction. Here you have given the appellate jurisdiction over the decision of village council, provided the case is referred by the deputy commissioner or any of the assistant to deputy commissioner under provision of the Nagaland Village and Tribal Council Act 1978, fit with relevant rules for administration of justice and police in Nagaland Area 7. This is a source of power.
The DB Court has appellate jurisdiction over decision of village councils, provided the case is referred by
In order to justify their stand, Worship, in the state government, they have filed an affidavit. In order to justify this stand, they have taken an order passed by this honorable court in the Tulazama case by Justice Circle in the contract. So, Worship, I may be allowed to refer to the counter affidavit by the state respondent.
in order to justify this order, they have placed the order passed by Honorable Justice Sato in their affidavit in opposition. Yes, where is the judgment of Justice Sato?
Yes, Lordship. Lordship, we come to the affidavit in opposition of the state respondent. Respondent number 123.
Affidavit 1, 2, and 3.
1, 2, and 3. A single affidavit they filed in this case.
Okay, which page?
Lordship, we come to page number 5.
Page 5.
Para 19.
Page
5, para 19.
Page 5, para 19. Yes.
May I read, Lordship?
Yes, please. Yes, please.
That with regard to the statement made in para 24 of the petition, it may be stated that the Honorable Court observed in its judgment dated 4/7/2017 as follows. Admittedly, the case of the parties was referred to the Court of TB, Chimugdima by the EC Chimugdima, who is Assistant to Deputy Commissioner Timapur. As such, the Court of TB, Chimugdima, did not commit any error of law in having assumed appellate jurisdiction over the decision of the Village Council of Tulazama Village. It is therefore submitted that, in view of above referred judgment of TB's judgment, the TB's court is having appellate jurisdiction. In case it is endorsed referred to the TB's court by the Deputy Commissioner or any of the assistant to the Deputy Commissioner. Question, we come to page number 10 of the affidavit. This is the judgment passed by Honorable Justice Suri.
Yes.
Lordship, the relevant portion, Lordship, not recorded in, read on the entire facts, only the relevant portion. Page number 12, the last, bottom paragraph.
Just wait, okay? Page?
Page 12, the last paragraph, the bottom paragraph.
Page 10.
12, Lordship, page 12.
Page 12, para?
Yes, the last paragraph, the bottom. Admittedly, it starts from.
Page 12.
The last-
Admittedly.
Yes, admittedly. Admittedly, the case of the parties was referred to the court of TB, Chimokidima by the EC Chimokidima, who is assistant to Deputy Commissioner Kimapo. As such, the court of TB, Chimokidima, did not commit any error of law in having assumed the appellate jurisdiction over the decision of the village council of Tulazuma village, and at the same time having disposed the appeal as it did. So by taking recourse to this judgment, the DC has passed the impunity.
Okay, after this, what happens?
Lordship, a review was filed against this one. The review was also dismissed.
Where is that review?
It should be the next page, the first paragraph. This is an application under This is an application under Order 4247 Row 1 with Section 114 of the CBC. And
Yes, the operative portion.
Bring for review. The operative portion, the last page. Therefore, I find no merit in the review petition, and accordingly, it is dismissed. Lordship, what happened was, in this Tulazamba case also, it was against the caution of the TB's court, sitting over the decision passed by the village authority. But Lordship, in that case, the provision of Rule 31 of the 1937 rules, that was not discussed in the case.
In this civil revision?
Yes, Lordship.
Civil revision?
Yes, Lordship.
What was discussed then?
Actually, since the issue involved was regarding the appellate jurisdiction of the DB, Rule 31 of the 1937 rules, that ought to have been discussed.
That was?
That was supposed to be discussed.
Rule 31?
Rule 31. But without discussing the Rule 31 of the 1937 rules, this order was passed in the revision.
And in this civil revision?
In the civil revision.
Yes, civil revision, what was the observation made by by Honorable Justice Sarkar?
In the civil revision,
Did he refer to any provisions of law?
Rule 23.
Rule 23A.
23A. Even by Rule 23, by interpretation of Rule 23E also, DBs they can try only the original cases, not appeal. So
Rule 23A is that provision which deals with endorsement of cases to Dibachi by a deputy commissioner,
Or his
additional
assistant.
deputy commissioner, or his assistant.
that also only original cases, not on appeal.
Yes, then what happens?
Yes, Worship. Worship, since this issue came up before before a bench of this court, so Worship, we come to the Worship.
After Honorable Justice Soto had disposed this case,
Yes, Worship.
you were making a submission that actually the coordinate bench had differed with this.
So Worship, we
So
come
what-
to the order dated 21/2/2019.
Is it in your-
It's in the report. 21/2/2019, passed by Honorable Justice N. Kudishwar.
In your petition?
No, Worship, in the report, it's been an order sheet in this writ petition.
In this, in order sheet, which order?
Order dated 21/2/2019.
21?
2/2019.
21 to 2019. 20, yes, just wait, okay?
Since by this order, the matter has been referred to a larger bench, so let's read the entire order.
Yes.
Order dated 21/2/2019.
Yes.
Heard Mr. So-and-so, learned counsel for the petitioner, as well as Mrs. So-and-so, learned additional senior government advocate for the state, so-and-so and so-and-so. The second paragraph. The present petition has been filed challenging the decision of the extra assistant commissioner, Chumbukitima, to refer to the DB's Toboshi's court, Chumbukitima, of an appeal preferred against an order passed by the Dibupar Village Council. Number 3. Certain land dispute case was decided by the Court of Dibupar Village Council in case number so-and-so against the respondent number 5 and 6. Being aggrieved, he filed a complaint before the EC Chumbukitima on 27/5/2017. Thereafter, the EC Chumbukitima White Order dated 30/5/2017 referred the matter to the DB's court for dealing with the said complaint appeal referred against the decision of Dibupar Village Council Court. Further, the EC Chumbukitima White Order dated 1/6/2017 issued a restraint order against the present petitioner. Being aggrieved, the petitioner have challenged the opposite decision of the EC Chumbukitima to refer the appeal complaint preferred by the private respondent number 5 and 6 to the Court of DBs on the ground that the DB court and the village court are of the same status, in the same hierarchy, and thus having coordinate jurisdiction. And as such, the DB's court could not have directed to hear the appeal preferred against the decision of the Dibupar Village Council. Number 5. The state has taken a stand justifying the order of the EC Chumbukitima in the light of a decision of this court rendered in Civil Revision number 9K of 2017, decided on 4/7/2017, in which this court held as follows. I've considered the facts and circumstances of the case in the provision of law submitted by both the learned councils. Section 22 of the Nagaland Village Council Act 1978 read as follows. Subject to general superintendence of the state government, the deputy commissioner, the additional deputy commissioner, or subdivisional officer in charge of the subdivision, extra assistant commissioner, or circle officer shall have control over all the village council within its jurisdiction, and Rule 23 of the Rules for Administration of Justice and Police in Nagaland 1937 reads as follows. 23A. The Toposhi henceforth shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to the Deputy Commissioner as the case may be. A cogent reading of the two provisions of the law given which are in practice in the state of Nagaland would show that the decision of village council appealable before the Deputy Commissioner, Additional Deputy Commissioner or Sub-Divisional Officer civil in charge of Sub-Division. EC or civil officer, however, the court of TB will also have jurisdiction to try such cases if the Deputy Commissioner or Additional Deputy Commissioner or Assistant Deputy Commissioner, as the case may be, referred to or endorsed the same. Admittedly, the case of the party was referred to the court of TB Chamugdima by the EC Chamugdima, who is Assistant to Deputy Commissioner Timapong. As such, the court of TB Chamugdima did not commit any error of law in having assumed the appellate jurisdiction over the decision of the village council of Tolazama village and at the same time having disposed the appeal as it did. Para 6. It may also be observed that the review petition filed against the decision in civil revision petition number so and so, being civil review petition number 12 key of 2017, was dismissed by the same court on 25/1/2019. Para 7. Accordingly, it has been submitted on behalf of the state that this court has acquitted EC Extra Assistant Commissioner as Assistant to Deputy Commissioner. As such, under Section 22 of the Nagaland Village Area Council Act 1970, it read with Rule 23E of the Rules for Administration of Justice in Police in Nagaland 1937. The EC Chamugdima is equivalent to Assistant to Deputy Commissioner, and as such, he could refer any appeal against the order of Village Council Court to the DB's court. Thus, after such reference, the DB's court assumes the appellate jurisdiction over the decision of the Village Council. Accordingly, it has been submitted that there is no illegality in such reference by the EC Chamugdima to the Court of the Bushes to deal with the appeal preferred by the respondent number 5 and 6 against the decision of the Village Council. Para 8. Learned counsel for the petitioner, however, submit that the opposite decision of this court is not in conformity with the statutes. As per Amendment number 4 of 1983, in the Rules 24 and 31 and other rules of the Rules for Administration of Justice, Nagaland 1927, the word Toposhi shall be inserted and shall be deemed to have inserted with effect from 1st December 1963 after the words Hitment of Kill, whenever the said words appear in the opposite rules. Para 9. Rule 24 of the Administration of Justice and Police in Nagaland 1937 as amended read as follows. Mozadar, Tangbura, Chief Hitman of Kills or Toposhis or other village authorities sitting with the village elders in council are empowered to try the cases without limit as to amount but with the following reservation. Clause E. He may not try suits in which a native of the plain or native of another village was not resident in the jurisdiction is a party. B. All suits be decided in open tabar in the presence of the parties in at least 3 respectable witnesses. Para 10. The petitioners contend that the village council court is a village authority sitting with the village elders in council and hence is competent to try under Rule 24. Similarly, Toposhi court is also competent court to try cases under Rule 24 and both the Toposhi's court and village council courts are mentioned under Rule 24 having equal and same jurisdiction. It may however be noted that under Section 14 of the Nagaland Village Council Act 1978, the village council earlier had jurisdiction and competency to administer justice within the village limits in accordance with the customary law and usages. However, the aforesaid Section 14 has been deleted by the Nagaland Village and Area Council Amendment Act 1985. Para 11. Thus, a reading of Rule 24 would indicate that the village council court is a village authority court which is authorized to try cases. If that is so, the court of Toposhis in the village council court would be at par, having similar original jurisdiction to try cases as provided under Rule 24 of the Administration of Justice rules. Para 12. Further, as provided under Rule 31 of the Rules for Administration of Justice in Police in Nagaland 1937, an appeal shall lie for the decision of the Mazatar, Kambura, Chief Hitman of Kills, Toposhis or other village or other duly recognized village authority to the tribal courts whenever considered, or otherwise to the deputy commissioner or his assistant. Rule 31 reads as follows. An appeal shall lie from the decision of the Mazadar, Konbura, chief hitman of Kills, Toposhis, or other duly recognized village authority to the tribal courts, whenever considered or otherwise to the deputy commissioner or his assistant. A record shall be made of the matter in dispute and the decision of the village authorities. If necessary, the court shall examine the parties. If the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the justice of the decision, it will try the cases novo or refer it to a tangiat as above. Paragraph 13. According to the learned counsel for the petitioner, according to the learned counsel for the petitioner, the village council is the village authority under the meaning of Section 24 as well as Rule 31 of the Rules for Administration of Justice in Police in Nagaland, 1927. In as such, the Court of Dobashis and village councils are placed at par and are having coordinate jurisdiction. In as such, it would be inconceivable that the decision rendered by the village council court would be challenged before the Court of Dobashis. Paragraph 14. This court finds force in the submission advanced by the legal counsel for the petitioner that if the Court of Toposhis and village council court are at par, as submitted at the bar, against whose decision an appeal would lie to the deputy commissioner or his assistant, it would be impermissible for either the Toposhis court or village council court to hear any appeal against a decision passed by the other court having same and coordinate jurisdiction. Paragraph 15. However, since this court has already passed an order in civil revision petition number 9K of 2017, as referred to above, allowing a court of Tobashi to hear appeal against an order of village council court, which is in the same hierarchy, which decision this court does not agree with. This court is of the view that this matter would require to be heard by a larger bench to decide on this issue. Paragraph 16. This court is of the view that the Court of Toposhis can certainly hear and decide any such civil cases, which may be referred to it by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to the Deputy Commissioner, as the case may be. But such civil case must be original in nature, in not of an appellate matter against the decision of a forum of coordinate equal jurisdiction. For example, there may be a situation where, because of certain reason, any of the authorities having original jurisdiction versus Mazadar Kambura, chief hitman of the kill, or such duly recognized village authority is not able to take up the civil case, or the Court of Tobashi on erroneous grounds does not to take up a civil case, the Deputy Commissioner or the Additional Deputy Commissioner or Assistant to the Deputy Commissioner may refer the matter to the Tobashis for trial. However, there cannot be a reference for deciding any appeal by the Toposhis against an order of the other authorities who have been placed at par with the Toposhis under Rule 23 and 31 as referred to above. An appeal can be heard by a forum which is higher in hierarchy than the authority which passed the order appealed against. Paragraph 17. Accordingly, the matter is referred to be placed before the Honorable Chief Justice for constituting an appropriate larger bench for deciding the issue as to whether any decision passed by the village council court can be heard and appealed by the Court of Tobashis, even if the same has been referred to it by the Deputy Commissioner, Additional Deputy Commissioner, Assistant to the Deputy Commissioner, under Rule 23E of the Rules for Administration of Justice in Police in Nagaland, 1937. Secondly, as to whether the office of the Extra Assistant Commissioner can be equated with the office of the Additional Deputy Commissioner, as has been held by this court in Civil Revision Petition number 9K of 2017, for the purpose of considering appeal for directing reference against an order passed by the Mazadar, Kambura, chief hitman of kills, Toposhis, or other village authority, since an appeal against those authorities would lie only before the Deputy Commissioner or his assistant as provided under Rule 31 of the Rules for Administration of Justice in Police in Nagaland, 1937. Under the opposite rules, no appeal lies to the Extra Assistant Commissioner. As such, he would not have the authority to delegate or refer any such appeal to the Toposhis. Paragraph 18. List the matter after 2 weeks para 19, since the matter has been referred to a larger bench for consideration of the issue referred to above, the status quo as on duty shall be maintained by all the parties as regard possession of the suit. Registries to take necessary steps for placing the matter before the Honorable Chief Justice along with the relevant records. So, Worship, in compliance with this order, the division bench has considered the division bench to hear the matter.
Yes.
Yes, Worship. Worship, the order passed by the reference court is order dated 4/12/2020. 4/12/2020. May I read, Worship?
Yes.
Order dated 4/12/2020. The present matter has been released on reference before this bench by the motion of an order dated 21/2/2019, passed by the then Honorable Mr. Justice N. Gurishwar Singh and presently the Honorable Acting Chief Justice of this court, which received the essence in the order of the Honorable Chief Justice, Vice Worship, order dated 13/5/2019 to release the matter before available bench at Kohima. But para 2. The prefix leading to the proposal for reference is summarized for the sake of throwing light on the legal lacuna which is involved in the present petition. Number 3. A land dispute arose for the sale of a block of land located at Kibubar A Kill, covered under Pata number so dated 8/6/2000. The land was purchased by late so from Mr. So in the late 70s. On the demise of Mr. So in 1996, the land was transferred in the name of Mrs. So, wife of late Inai. The block was allegedly sold by Miss Yashila Chamir to the Kenny Society by a sale dated so for a consideration of rupees 29,60,000. Thereafter, 2 complaint letters were filed before the Kibubar Village Council by Sri Swensu, son of late Inai Chamir, and the same was registered as case number 1059 dated 7/1/2007. Number 5. On trial of the case, it was found that the sale deed was executed by means of forgery by Srimati Swensu, daughter of Swensu. She put the thumb impression of her mother on the sale deed. She also did not inform any of her brothers on the issue. Having discovered this, the Kibubar Village Council disposed of the case with the direction that imposing a fine of rupees 15,000 only to Srimati Indila Chamir, cancel village pata number so dated 9/3/2016, standing in the name of Tolo Go Angami, which was transferred from Ganesh Society, shall be reverted to Yashila Chamir. Number 3. Miss Yashila shall refund rupees 29,60,000 only towards the cost of land. Mrs. Yashila shall also reimburse rupees 5,40,000 only towards the expenditure incurred by Ganesh Society after the land transaction. All the parties were directed to comply to the above verdict within 15 days from the date of decision. Para 6. Agreed with the above decision, the Kenny Society filed a complaint against the chairman of the Kibubar Village Council before the EC. Upon receipt of the complaint, the EC Chimukdima by order dated 35/2017 under letter number so endorsed the case to Topashi's court for trial. Thereafter, objection was filed by Mrs. So, wife of late Ina Chamir, and Mr. So, son of So, on the maintainability of the petition filed by Kenny Society dated 27/5/2017, which was endorsed to TB's court Chimukdima. Perhaps the same objection was brought to the notice of DC Timago, who has clarified that TB's court has appellate jurisdiction over the decision of village council, provided that the case is referred by the deputy commissioner or any of the assistant to deputy commissioner under the provision of the Nagaland Village and Tribal Council Act 1978, read with relevant rules for administration of justice in police in Nagaland 1937. This was conveyed under letter number so and so dated 21st July 2007. It is against those two orders of the EC, Jamudima dated so and so, endorsing the case to DB's court Jamudima to hear the appeal against the decision of the Village Council of Kibukar. In the order of the DC Timoport dated 21/5/2017 under letter number so and so, directing the EC Jamudima to take up the case as an appeal, the DB's court having the power to hear appeal against the order of the village court. The main challenge was that the rules of administration of justice in police 1937 under Rule 31 provide for appeal against the decision of village court before the DC, ADC, assistant to DC, and not before the DB's court or EC. EC is not assistant to DC, and no appeal lies to his authority on appeal against the decision of the village court. On examination of the matter before the learned single judge, it was observed that the argument forwarded by the petitioner was found to be in accordance with the provision of the rules of 1937. However, the learned single judge was confronted with the ruling of a single bench in civil revision petition number 9D of 2017, allowing the court of DB to hear appeal against an order of village council court. After having examined Rule 24 of 1937 Act, which statutory provides that the Toboshis and the village court have coordinated original jurisdiction, and also on interpretation of the Rule 31 of the 1937 Act, which provides for an appeal against the decision of the village court to DC, EDC, or the assistant to DC. The learned single judge differed in opinion to the judgment rendered in civil revision petition number 9D of 2017, which was decided on 4/7/2017, and placed the matter for reference to this bench with the undermentioned issues. Whether any decision passed by the village court can be heard on appeal by the Toboshis court. Whether office of the EEC, Extra Assistant Commissioner, can be equated with the office of the Additional Deputy Commissioner, as has been held by the learned single judge in civil revision petition number 9D of 2017. When the matter was put up for consideration before this bench, the learned counsel for the petitioner, Mr. So and so, submitted that the same nature of issue was settled by the division bench of our own High Court in the case of Yongpong Ao versus Head Tobashi Mokchong and others. Civil Rule number 633 of 1981 passed on 19/4/1989. The Putumundan of Takwa village, which is the village court for the Ao Naka tribe, was recognized under 1937 rules on 29/6/2017, had settled a land dispute in favor of Yungkong Yapang. The bill was preferred against this village court, Putumundan, decision before the Toboshis court, Mokchong, which was challenged. It was decided that the appeal from the decision of the village court, Putumundan, would lie before the Deputy Commissioner, Mokchong. Accordingly, the DC Mokchong was directed to dispose of the matter in accordance with the law. He has therefore pleaded that the matter is no more risk in the and matter may be disposed of accordingly. The Learned Counsel for the appellant has also taken this court on a visitation to the various amendments brought about in the rules of 1937 to cooperate this case. The amendment brought about are indeed numerous in historical study of the progress of evolution of the 1937 Act, which has not been complied in text in an intelligible manner, may however not be very useful for the purpose of answering the question at hand, which is required in brevity to understand the rules of 1937 Act as it stands now at hand. Para 10. Furthermore, it has been argued that the Honorable Single Judge could not have passed the order dated so and so and civil revision petition number 9D of 2017 in Tunazuma Village Council, Village Roma Bombay, ruling that on coaching rating of Section 22 of the Nagaland Village and Area Council Act 1978 and Rule 23E of the 1937 Act, the Toboshis Court has an appellate jurisdiction if on endorsement by the DC, assistant to DC, or his assistant, despite the existence of the ruling of Yungong Ao, which has not been overruled by a higher court. The provision of Rule 23E of the 1937 Act would not be enlarged in its interpretation to embrace hear and decide civil appeals, as is much as trial in civil cases are quite different from hearing and deciding criminal appeals. Para 11. Appearing for the state respondent, Mrs. V. Superintendent Additional Senior Government Advocate has defended the impugned orders by citing Rule 23E, which provides that the Tobashi shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to the Deputy Commissioner, as the case may be. Her argument is that the EC, being assistant to DC, was empowered to refer the case to the Tobashis by virtue of the provision of Rule 23E of the 1937 Act. Once the EC exercising its referral power of assigning the duty of trial to the court of the Tobashis, it could try the case against the decision of the village court. As an appellate court, she has placed reliance upon the decision of a single bench in the case of Tolazamba Village Council versus Trauma Bombay in Civil Division Petition number 90 of 2017. In the above cited case, the learned single judge of this court has ruled that the Tobashi's court can sit on appeal against the decision of the village court referred by the DC or its assistant. She has argued that the order dated 35/2017 endorsing the case filed on appeal against the decision of the village council court of Kibupar in the letter to the DC endorsing the view that the Tobashi's court have the jurisdiction to sit on appeal against the village court decision by letter number so dated 21/7/2017 are in keeping with the provision of the rules 23E of the rules for administration of justice in police 1937. The present writ petition must be dismissed in the light of the provision of Rule 23E and the decision of civil revision petition number 19K of 2019. The condition of the parties with respect to the issues are heard and considered. The provision of the rules for administration of justice in police in Nagai Hills, District 1937, which was prescribed by Governor of Assam in excess of power vested under Section 6 of the Scheduled District Act 1874, has now been amended to be called the Rules for Administration of Justice in Police in Nagaland Amendment Act 1974, Nagaland Act number 7 of 1974, having attending statute. It has gone through a series of amendments as per the changing requirement of time. There are several occasions where conflict within the provision of the 1937 Act surfaces. It will not be profitable to overburden this judgment with the narration of the historical amendment made with the provision of the 1937 rules. We therefore,
What is the operative? What is the operative?
yes, Worship is a very lengthy judgment.
Yes, what is the operative?
Worship, we come to the next question. Para 16.
What is the operative judgment of this
Yes,
honorable division bench?
Worship, it start from para 16.
Para 16.
From the literal reading of the
Just wait, just wait. Yes, para 16.
From the literal reading of the provision of Rule 31, with respect to appeal before the DC, EDC, or its assistant, it is clearly discernible that when the appeal is brought before the DC, EDC, or its assistant, the court shall examine the parties. And if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the justice of the decision, it will try the case de novo or refer it to the Panchayat as court. Thus, the plain reading of the provision of Rule 31 does in any way give authority to the DC or its assistant to forward cases of appeal to any other court but to the Panchayat. Therefore, an appeal forwarded to the court of Toposhi from the decision of the village court is divorce the provision of the appeal rules of 1937. Which is the thing. The Rule 31 is crystal clear that when appeal is preferred from any of the Mazadar chief headman of Kiel, Toposhis, or duly recognized village authority, it will, if satisfied, enforce it as its own. If it has reason to doubt, it will either try the matter de novo or entrust it to the Panchayat. The GC or its assistant will either try the appeal petition de novo by itself or refer the same to Panchayat. From the decision of all recognized courts, including decision of the Toposhis. The above being the clear provision of the Act, EC of referring the appeal to the Kipubar Village Council to the Toposhis Court, Chimukdima, was violative of the provision of appeal under Rule 31 of the 1937 Act. This is the main finding of the reference court. In the remaining paragraph also, all those are just a repetition. And Lordship, the term of reference is answered in Barat 23. Two issues were referred to the reference court. That has been answered in Barat 23.
Yes.
May I read? Having discussed the point of reference, we now answer the issue of reference as under. Toposhis cannot be empowered as appellate court by the exercise of power under Rule 23E. Rule 31 debars GC, EDC's any assistance from such authority. Number two.
Just read once. One, Toposhi cannot be empowered as
Toposhis cannot be
appellate court
empowered as appellate court
by the exercise of powers under Rule
23E.
Rule 31 debars DC,
Any
ADC, and his assistants
such
from such authorities. Okay. Office of EAC can be empowered as an assistant to DC under 1937, provided the government declares so.
So, Lordship, my submission is, since the main issue involving the present rate petition has been decided by this reference court, holding that under Rule 23E, the EC has no authority to refer the matter to the Toposhis court. In the present case, the issue has been arose due to the action of the EC Chumukdima, referring the matter to the Toposhis court. So, since the matter has been already decided, so the imbued order will be quashed.
So what you mean to say is that if the respondents are still aggrieved by the order passed by the village court,
they can approach the appropriate form.
they can approach the appropriate form.
But the issue has been raised by the private respondent number 5 and 6 in the present case, saying that a writ petition, a writ of certiorari cannot be issued against the judicial order. So my submission is,
Which is the judicial order here?
no. According to me, there is no judicial order. Judicial order can be considered only if the order is passed by a regular court. So, Lordship, the imbued order will be quashed in the party may be given the liberty to approach the appropriate form. If so,
Madam Sokre, do you have your submission?
Lordship, as per the order of the reference court, Lordship, I have nothing to
And
say.
what about Madam? Do you have any? Do you have submission?
Yes, Lordship, I have a short
Okay,
submission,
then we
Lordship.
will hear you on Monday.
Lordship, it's just a short submission.
Yes,
just
we will
2
hear you
minutes.
on Monday. We will hear you on Monday. If you don't have submission, we will dispose as per the order passed by the division bench.
Your Lordship, it will be just a short submission and not I'll leave it to the wisdom of this honorable court to decide. Just
Let us hear on Monday.
mali udah satu kena, mali udah satu yang judicial order, mali udah kena sama.
Step with it. So the case is more or less decided by the division bench.
Yes, Lordship.
Heard Mr. Limawa, the learned counsel for the petitioner. MS P. Sokre, the learned counsel. for the state respondents and MS so-and-so. Your good name?
Asna Wali.
Asanna Walling, the learned counsel for the respondent number
5 and
5
6.
and 6.
5 and 6. Listed as a part-heard item. Monday. Listed as a part-heard item on?
Or Lordship, when the matter is fresh on 8th, day after tomorrow.
No, not Thursday, Friday. Thursday, Friday, at least give us time to write judgments.
Lordship, then tomorrow.
Tomorrow is
My
a day.
Tomorrow is Wednesday.
There is no debate.
Listed on 12/6/2023 as a part-heard item.
Lordship.
Item number 58.
Yes.
May I please the Lordship?
Yes.
Lordship, this is an appeal against the.
Where is the other party?
They were here, Your Lordship.
They were here. They are not here now.
They're not here.
We'll list it some other time.
Lordship.
Mr. V did not. Appears for the appellant. None appears for the respondents. Listed again on 12/6/2023.
No, Lordship.
Aisha.
Computer section, court खत्म दे